Well, good morning, everybody. Earlier than the usual, but this is a special event, obviously. Good to see you all in here. Of course, we're waiting for the Chille appeal hearing, the appeal hearing of the century to start here. We're going to be watching our Nevada judges starting at about 9 o'clock. It looks like we're not sure if Alex from our Nevada judges is going to be doing any commentary ahead of time, but it looks like perhaps not. Hey, Prissy, thank you for becoming a YouTube member. Good to see you. Good to see everybody in here. We do have special guest Patrick Darcy. If you want to say hi, Pat. We are just saying morning. There you are. Oh, can't hear you. You got your mic on? Can we hear you? Pat, do you have your mic on?
Yeah, sorry about that.
Oh, okay, no problem.
I got to fix the background. It's got all kinds of fuzziness.
Fuzzy background. Well, we are excited to have you all here. As I said, this is now P-Docs, who's currently over in the ONJ chat. I saw he said that according to the jail website, Chille has accrued some good behavior time. He said at this rate, his new release date is something like the 28th or something like that, or some 24th, something like that. I didn't know that was a thing. So my prediction is this is going nowhere, based largely on Pat's incredible insights that he's been providing for us this whole time. So we appreciate that. I don't. Is Linda in here by any chance? By the way, we can do something about this spamming stuff. Let me see if perhaps I can. Yeah, I'm not doing any kind of spam shit. So sorry, that will get you banned around here. All right. So, what do you think, Pat? He stays, or will he stay, or will he go free?
How do I reduce the echo?
Do you have an echo cancellation? Oh shoot, there's Ram. Sorry about that. There's an echo cancellation button under your audio thing. You're hearing echo.
Yeah, I was beginning to wonder.
Oh, sorry, buddy.
I'll take care of that spam. Let me get on my other browser.
No, I got him. That's the only thing, pretty much. That Terminator.
I think Linda's over in the.
We're good. We're good. Yeah. Do you have headphones? You don't have headphones, right, Pat? So, is the echo real bad on your end?
I'm okay with it. It's a little bit of a delay.
Okay. We don't hear it on the broadcast, so I think if you can live with it, we're okay. So my prediction is Chille stays right where he's at. And obviously, I believe that's your opinion as well, Pat, because I'm basing my opinion on your opinion. So that sort of logically follows. But any other thoughts on the proceedings this morning? What we're going to see, Pat?
Yeah, a few things is whether or not how much time they're actually going to give each side to argue. I figure maybe 10 to 15 minutes.
Right. Yeah. So they are going to have the opportunity to make other presentations. Do you think Chille is going to say anything, or is he even able to get up? Are they able let him say a few words. Is that a bad idea? If it is possible, what do you think, Pat?
No, they're not going to let him speak at all. And what usually happens is the appellant, the one appealing, goes first, and then they reserve time for their final rebuttal to what the other side says. So you'll never usually see the first side use up all of their allotted time. But Chille's not going to say a word, and he's probably been
Yep.
instructed to stay quiet and not react, which is good advice for anyone.
Yeah, absolutely. Yep. If you're not sure, don't say anything. Better to be silent and thought a fool than open your mouth and remove all doubt. As they say, Daniel, O&J is our Nevada. How do they like it pronounced? Nevada judges. But excellent channel, and this all is coming courtesy of them. So, and we're also very indebted to Mr. Darcy for many reasons, but also for facilitating all this. Appreciate that very much.
Are you going to snipe it here, or what?
Nope, it will. You'll see, it'll all work out. It'll be beautiful.
So it's going to broadcast here. What you're saying?
Yes, we will be broadcasting.
Okay. That's what. Okay.
Hello, Shiz. Good to see you. I saw MSG in here earlier too. Of course, Yvonne, Logan, Glober Mom, Scott, Chloe, Angels for Animals. Oh, the whole gang's here. Misty, Double D's, great name by the way. Yeah. So this promises to be interesting, as all things Chille do. Yeah, I don't know, Gorilla Spawn. Apparently, Chille has been taking some. He made a reference on the video we watched last night. He hasn't really mentioned it that directly for a while, but he mentioned that his channel's revenue has gone way down. But it is true. That's for sure. He only makes as much as a poor fast food worker now. That's what he said. Or a couple months ago, I guess it was now. It'd be nice to be still pulling in money while you're in jail. But hey. All right. And I don't know if we're going to get any comments from Alex. We'll see.
Oh, hey, by the way, Dick Bag.
Yes.
I changed my background to the chapel at Georgetown University because if there was ever a time for Chille to pray, it's right now.
Yeah, there you go. Yeah, that would be probably his only hope at this point. By the way, our little poll now, maybe I'll try and share that screen before they get started. Let me see if I can pull that up. We definitely don't want that. Sorry, guys. This is earlier than I usually try and. Anyway, we had a little poll going on the channel as to whether or not Chille's going to get released. Let's check and see where we're at.
No, not getting released.
Yep, that's my opinion too. I do want to see what the poll says. Oh, for God's sakes. Oh, there we are. All right, here we go. No, that's not it. God's sakes. Oh, let's see. Can you guys see that? Are we seeing this? Yeah,
He's not
our
getting
little
released.
poll. Yep.
No.
According to our poll, 4%, a mere out of how many votes? 273 votes. Only 4% think he's getting released. 60, a whopping 68% think not a snowball's chance in Nevada, and coming in second, as always, with 27% of the vote is Corey Feldman. So there you go. We'll see how accurate our poll is. I feel like it's pretty going to be pretty good, pretty close to that. And let me make sure I have the judges show. Should automatically switch over once they start. All right. And yeah, I know, Dummy Kruger. Good to see you, by the way. Yeah. Corey Feldman perpetually in second place. Has anybody, by the way, I know he is going on some kind of tour with Limp Bizkit or something. Anybody got tickets to that? Anybody seen Corey live? Anybody planning on going to that? I'm very curious. There's got to be at least one lunatic out there who's into that. Nope, nobody. Well, wait a minute. Yeah, you got. It looks like Dummy. You got some. Even Swamp too. Got some damage. I feel you, buddy. Swamp here too, but I'm very, very grateful that we have this opportunity to be. Yes, thank you, Linda. Please hit the like button. If you're not subscribed, subscribe. All that good self-promotion stuff. Anybody else's belly button just puckering and unpuckering in anticipation? Yes, the Loserville tour. That was what. That is what the tour that Corey Feldman is on with Limp Bizkit. Pretty on the nose, but I prefer Danny Bonaducci as a musician. Wow. 70s Bonaducci, or does he still play music? God, I forgot about that guy. He's in the Where Are They Now file.
I met him once at school.
Danny Bonaducci?
Yeah, there was a high school nearby, and I ran into him. He was pretty easy to spot, and that was during the Partridge Family era. He was actually pretty cool.
Oh, nowadays I would have guessed janitor at the building you work at or something like that, but that's funny. He's been a radio host in Seattle. I see. Well, I'm glad we're catching up with Danny Bonaducci, where he's at. Somebody said he's a radio host in Seattle. Oh, there we go. Yeah. You sold your ticket to Coded, Surrender Monkey, on condition he took Welsh. Well, that's a pretty good deal. I would go along with that. Corey Feldman is the best. Absolutely. Is my mic quiet? I'm sorry.
Leave it to
Logan, oh my God. We've got Danny Bonaducci stalker stories happening. Hughes Morgan and Woodland Hills, huh? We'll have to have you on to talk about that.
Oh, hey, Dickbag.
Yeah.
Can I say there's such a delay? I don't know when to talk, so I just kind of jump in. Sorry.
Sure. Yeah. Please.
Somebody said, "Tell me you went to Bridgetown one more time, Pat." Logan Sandman. The reason I said that was because I don't want to claim any copyright ownership of a photo of a school. It's not allowed. And if they know me, they already know I went there. And I thought it was funny because I will tell you right now, there is a lot of praying that goes around the courtroom. So that's the reason why I put the picture up, and that's why I said that.
There we go. You were never the cousin on the Brady Bunch. Is that correct, Pat? Somebody was saying, you might be cousin Oliver from the Brady Bunch.
No, I did watch the show a lot.
Yep, I think we
You got
all
some
did.
great names in this chat. Double D's and Rack the Jipper.
Yeah. Yep, we have some fun names. Yeah, the Brady Bunch house it's not too far from where I live. I've been by there. And also the Happy Days house. It's kind of strange to see that stuff in real life when it's sort those establishing shots of the buildings are sort of imprinted on all of our brains probably somewhere,
Weren't they taking a lot of them down?
No, well, I think they built a fence, a short fence or something around the Brady Bunch house, but I mean, you could still see it.
I know some of them they were going to take down, so they did like a final tour in them.
Yeah. Well, Hollywood's not real great sometimes about preserving stuff like that. If a lot of things do get torn down, but it,
Yeah, the Christmas Vacation one. I think they were.
Well, that's a different story. That's Warner Brothers Ranch. That's Warner Brothers Ranch. They tore the whole thing down. They're going to build some horrid condos or something, for people. That's right. And that's where the
and put up a parking lot.
La la la. Yeah, exactly. That's the Bewitched house, the I Dream of Jeannie house, Christmas Vacation house, which is also the Lethal Weapon house. Actually, it dates back way back to the
that octagon window up in that eave was pretty notorious, wasn't it?
Yes, and then believe it or not, it was based on a real street called Blondie Street in Studio City, thus named because they did a bunch of the Blondie movies. And, I don't know if this is way off the Chille topic, but why not, right? So Blondie is a terrible cartoon that ran for it might still be going on for all I know. Do they still print newspapers and comics?
Yeah, really.
I mean, if it is, Blondie's probably still going, but literally it's just about a guy whose wife is blonde and he eats a lot of sandwiches. That's the whole premise of the cartoon. It's really dumb and boring, but believe it or not, there were literally 30 Blondie movies, something made in whenever it was, the 50s. It was a huge movie series, and they initially filmed on the street in Studio City using the house, and they eventually just rebuilt a lot of it on the back lot at Warner Brothers.
Yeah, it was Dagwood and Blondie.
Yeah, Dagwood Bumstead. There you go. Yeah. So anyway, there's your little
Dagwood. Oh my goodness.
Yeah, Dagwood. What a fantastic name. If anybody's looking for a name for their kid, there you go. I think there's actually a sandwich named after him.
My spider monkey.
Those were the Sunday morning comics.
Yeah. Yeah, I remember, reading all that. You had all your Blondie and your Marmaduke and your Hagar the Horrible and all that stuff. So that's all gone now. Unfortunately, all that Hollywood history was torn down to build condos. Warner Brothers sold it off to some developers, and now it's all gone. There's a bunch of YouTubers that cover filming locations and things like that. Actually, one of my buddies managed to get on to the ranch before they tore it down. I would have loved to have seen that because there was an awful lot of TV history and movie history.
It says here that Blondie's the third longest running newspaper comic strip that's still going.
I believe it.
Next to Gasoline Alley and Barney.
Gasoline Alley? Oh my God, Barney. Yeah, it's man, yeah, wow.
Gasoline Alley, 1918.
Yeah.
Do you guys remember BC?
Oh, sure. Yeah, the caveman one. That's crazy.
DC was pretty good.
Oh, sorry, we got some chats here too. Edward Wildenhain. I don't think I've seen you here before, but welcome. Is AI Chille watching? He's always watching, buddy. He is always around somewhere. He's, virtual. He's in the ether there. He knows if you've been bad or good. So
5 minutes.
He's
5
in
minutes.
Give me a warning. Everyone's lining up in the courtroom.
Da, 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 da. Exciting. Touche. Member for 3 months. Thank you. Ed Utapod's a new member. I like your name. I don't know what it means, but I would like to subscribe to your newsletter. Thanks for being here. Marshall, member for 3 months. Good to see you. And Prissy is always good to see you around here too. Just became a member. Thank you.
Hey,
Ooh,
Flat Derp.
boy. Hey, Derp. What's up, buddy? Boy, you got those last few phone calls of Chili's. There's literally one where, what did he say? Oh, what did something happen here? Oh, here we go, gang. All right, I'm going to just take us off screen just to prepare, and we're going to be ready. We're going to be ready. And welcome, Steve, as well, sir. All right. Stand by. And hey, Mo. Welcome, Mo. Member for a month. Appreciate you. All right. My ONG music is going.
All right, let's add to the anxiety.
Yeah, exactly, because I don't hear nothing. You guys hear anything on there?
I hear the music.
You do? I do not. Hold on. Okay, there we go.
Now, what the big fear is right now for the people that are going to have to do oral argument, which I expect to be Courtroom and the prosecutor, I forgot his last name, is knowing the cases.
Oh, sorry, I'm trying to turn this volume down. Say again.
That's part of the advertisement. We hadn't started yet.
Okay, all right, cool. Alrighty.
So the big problem, if you're doing this forum or the prosecution, is getting hit with a case you haven't studied or don't know, and then you freeze. That's the big fear.
Gotcha. That's a big, okay, something to look forward to. Or
They
look
both
for,
brief
rather.
Wilson.
They what? They both what? Sorry.
They both brief Wilson, and Wilson has an exception for passing physical conduct that will count as physical conduct and obstruction.
Right. There we go. And a question: could Chille face more? Well, it's not prison time, but jail time for $2 from the discussion, or £2 from the discussion saloon?
No.
Yeah.
That would be double jeopardy. It's over. He gets the sentence he gets. He can only get less, or can't get more.
There you go. Oh, thanks, Terry, for the memberships. Gifted 5.
Or reversal.
Reversal. Gotcha. Now he does have another. Yeah, I think this is just the.
Well, hello, everybody.
This is just the ad thing that's going.
Change my perspective. She may not know that.
No, I don't know if we need to.
How I am the way I am.
I don't know if we need to hear that right now. That's just a little trailer thing that they had going on.
Remember this: the calendar may not be called yet for this case, so it's not going live until the calendar is called.
Gotcha. And we don't have any way to know until it really happens, I guess, right?
That's right. Alex said it'll probably go first.
Go for what? having an enjoyable beverage. You, the last part cut off there, Pat. What were you saying?
Alex says it's probably going first.
Yeah, and even Chille mentioned that on his phone call yesterday. They tend to do the media cases first. So, yep. Angel, yes, thank you. Appreciate whoever got those memberships. When does he get out? Well, apparently it's end of July if this appeal doesn't happen today, which likely won't. But apparently he does have some time off for good behavior. Unbelievably.
According to him.
Well, no. PDocs, the public documents, said that according to the jail
75%.
website, yeah, so he is a very reliable source, in my opinion.
It is.
And
But the unreliable part is all the times he said he got put in the hole. That wouldn't be good behavior, would it?
Your guess is as good as mine.
Yeah, I doubt he went to the hole.
I couldn't tell you. But we'll say, if you're not familiar with the public documents, it's an absolutely indispensable resource for information on Chille, and we're glad they're around. Did any of you guys watch this little trailer thing? It's got some celebs in there. We got Artie, and seen a lot of talk with Mike and our buddy Skeptic, all talking about Chille. And it looked like they had some little. Here we go.
There we go.
Waiting for the case to call. All right. Okay. Let's get the volume back on here.
Today, we're going to be talking about the First Amendment, what happens when it runs into the police's ability to do their job on the scene, and we're going to be talking about Jose de Castro, who is currently serving 6 months for obstruction and resisting in what started as a filming incident at a traffic stop. He calls himself a constitutional law scholar and says that he is providing a public service by documenting police activity, and things kind of escalated. We're going to talk about that case, and I am happy to have two guests with me today. We've got Lisa Zick. Yes. I didn't want to mispronounce that. And Anthony
Bandiero.
Mr. Bandiero does training for Las Vegas Metropolitan Police Department.
All the agencies here. I teach pretty much every agency.
Yeah, has for years. And Ms. Zick is a criminal defense attorney.
Yep.
As am I, but we promise we're not going to tag team Mr. Bandiero on this. We're going to have a open discussion.
Yeah.
So, Mr. de Castro, you've had the opportunity to watch the trial and the video, both of you. What were your initial impressions?
So initially, I thought that the arrest should have never occurred. I think that he was not obstructing. And I think it will be interesting to see what Judge Levitt does with it on appeal. I think that he has created some interesting issues with his courtroom antics and post-conviction behavior, but his behavior on the day, at the time, the filming at the traffic stop, I don't think it rises to the level of obstruction.
What's an officer to do, though, when they've got somebody who is in their face and confrontational? And we can agree, Mr. de Castro seemed to be somewhat confrontational, right? Go back and do your job, little doggy.
Sure.
Those kind of comments.
But first I want to address the comment in your face. Is 10 feet really in your face? The court record indicates that he was 10 feet away. Is that in your face?
It's a good question. How close is too close?
So first of all, I want to say that, my views are just mine. I do teach a lot of agencies here, and this issue is still being litigated, and one of my clients is involved in this case. But I will say this, is that this is a tough situation. I mean, these police officers are tasked with a very tough job, and officer safety is a legitimate safety concern. But we also don't want to, hyperbole, right? We don't want to think that everybody is out there to kill us. That's not a good mindset either. That's actually a very unhealthy mindset. How close to too much? I will say at the end of the day, what I teach my officers is that when it comes to obstruction, is that you basically cannot effectively do your job. And I compare that with efficiently, right? A lot of these First Amendment auditors will do things where it causes you cannot efficiently do your job. You have to, talk a little louder. You have to, maybe, take your attention away and maybe address them for a little bit. That's not so efficient, but it's also maybe not illegal. I'm not saying we haven't really got to the brass tacks of what Jose's done in this case, but I'm just saying that's generally speaking, how close is too close? The officer, what I teach and my principles is that the officer cannot effectively do their job.
And you say First Amendment auditor. What is a First Amendment auditor? This is a newer term. I mean, I've done this job for 30 years.
Yeah.
It's the first time I've heard that. Maybe I need to be more into social media.
So interestingly, in preparation for us to have this discussion, did a quick little, search on Google to see, because there are lots of definitions for that.
I'm getting some double talk from somebody. I don't know who that is. Somebody has their I'm getting some double talk from somebody. I don't know who that is. One of you guys has your
Not me.
has your audio on. Oh, okay. Yeah. We'll have to adjust that because that will get old real quick.
That phrase, because it is a relatively new
Right,
phrase.
see.
And there are two prevalent internet
So far, yeah.
definitions for what is being defined as a First Amendment auditor. One is exactly the behavior that Mr. DeCastro is engaging in, those that pull out their phones and record police activity. And another is people who pull out their phones and record activity in any public space. So it goes beyond that of a just police activity. But if I walk into a commercial business and I pull out my phone and start recording interactions between a patron and a customer, if the employee at that business calls the police on me, they have failed essentially that First Amendment audit, because the argument is that you should be able to record any interaction in any public space. And that puts us down a completely different rabbit hole than from today's conversation. But I thought it was an interesting point of view because it kind of ties into, I think, Mr. DeCastro's point of view and where he was at when he was recording the police interaction in the traffic stop.
So is the position of these folks that in public spaces there is no privacy?
Essentially, yes.
Generally.
That's the idea, and particularly with officers. Of course, officers have body cam now.
So they're recording themselves. But I would also say, just before we go on to that, because I think that there are actually two types of First Amendment auditors. There's the first 1A auditor, want to be cool about it, The first 1A auditor is those who just want to record. They just want to see police officers. They're actually hoping for a good outcome. They're hoping that the Constitution is complied with. And then there's the other First Amendment auditor who's like DeCastro, who is really after three things: money, badges, and fame. They don't want to just watch cops succeed. They want to watch cops fail. And the way he acts, what he says, the words he used, go back to your job, little doggy, whatever, I mean, he says all kinds of things. He does not want to see cops succeed. Yeah, he actually makes it very clear that he is very anti-police. And I just want to be clear that that's something to consider. But generally speaking, it's not illegal to record police officers in a public place doing a public act.
Or to be anti-police.
Or not to be anti-police. Absolutely. He absolutely has the right to be anti-police. Absolutely. And he has the right to say that during his presence.
But in this situation, there's no question he's antagonistic.
Correct.
Right?
Oh, for God's sakes. Sorry. Just wanted to he interrupt us really quick. I don't want to get cut back up. If you didn't see this was from a couple months ago. These folks discussing this case, Chille's case. Hang on a second, guys. Sorry. He is. He's still. It'll be interesting to see how heavily they lean on this, on the filming stuff, because he keeps saying, it's about him filming, but as we've established, it's clearly nothing to do with that. So, will be interesting to watch.
Since part of this is whether or not you're stopping an officer from doing his job, right? That's part of the.
I think so.
Part of the fundamental definition, I would think, of obstructing. And in this instance, before DeCastro is ordered to go to the police car, he lets the motorist go.
Right.
His job is done at that point. And the resisting's about the walking to the police car, which DeCastro's doing. He's disgruntled about it, but he is doing it. I'm a little, it seems like we're having it both ways to some extent, if that makes sense.
The only thing I will say about this, and I love your point of view on this, is that at the end of the day, if we believe that a crime has already occurred, that he's already obstructed, which we can debate about that, then he's allowed to now have discretion. So you know what? I have a bigger fish. You're my small fish. You were just committing a very minor traffic violation. In fact, it was like registration issue. You're out of here. Now I'm going to deal with him.
Sure, but what would the normal everyday obstructing, would it always result in an arrest?
No.
Again, well, it's discretionary, right? And so many years ago, I had a case that was kind of similar to this, where it was a traffic stop and it was a sovereign citizen case, which again, another rabbit hole, but officer asked my client for a driver's license. He didn't have it because he had a constitutional driver's license, and it led to an obstruction and a resisting charge because my client couldn't produce a driver's license. And so ultimately, as my client was shuffling through these papers trying to find his constitutional driver's license, the officer felt like he wasn't complying with the command fast enough and ultimately pulled my client out of the car, which led to the obstructing and the resisting charge.
Now I'm sorry, I gotta pause that right there. I'm sure that's not the whole story. We all know the sob sits. They know the guy was definitely not just quietly and politely shuffling through his paperwork. Yeah, Pat could probably verify that. He's watched a lot of those sob sit videos too. That's not their MO.
It is a very interesting not DeCastro got arrested for anything he physically did, because there's a real question whether there was any physical obstructing in this particular
There's a legitimate question. I think that's something that should be viewed on appeal, right? I think that's not something that actually really got into at the trial level.
I would agree with that.
Yeah, that's probably a missing ingredient for me, at least. I would like to know that, because I would like to talk to you about the Wilson case.
Hang on, Pat.
That may help define whether or not DeCastro is violating.
Say that again, Pat.
I don't think there was any question about obstructing because of what he said when he was interacting with the cop. He said no twice, and also passive aggressive conduct under Wilson will be deemed physical acts.
Yep.
And I expect Judge Levitt to focus on that exception to the physical actions or fighting word.
Gotcha.
Wilson is a lady in Carson City. She is observing a police interaction with a suicidal juvenile. And I'm sure it's very tense. According to the case, the kid had a knife to his body. I'm probably thinking throat, right? And he's suicidal. So Carson City SO Sheriff's Office is trying to get him in custody for what they like a civil commitment, because he has to go get checked out. And throughout the whole time, Wilson, for whatever reason, is yelling at these police officers. I don't know if she maybe disagrees with their tactics, something about it she doesn't like, but she's targeting the officers. They tell her multiple times to, hey, police, stop yelling at us. We're trying to focus on this poor kid. You're obstructing us. She will not stop her behavior. And at the end of the day, they did get the kid in civil, in custody, civil commitment. They then went to her and said, Wilson, you're going to get a ticket, right? You're going to get arrested, or not arrested, cited for obstruction. And she goes to trial. She loses. And it goes because she is taking away the officer's focus, right? The officers, in a sense, cannot do their job efficiently when they have somebody like Wilson yelling. We all agree on that. So it goes to the Nevada Court of Appeals, and they say, hey, timeout. That's not really what obstruction is. Just because you have a person engaged in the First Amendment, what was her intent? If you look at the NRS, what was her intent? Did she willfully try to delay, obstruct, hinder? No, none of you. Well, maybe, but you haven't proven that. All you said was that in the trial court was looking at, did it have the effect of delaying their investigation? Yes. But what is her intent?
Yes, Oklahoma, it's because Channel 8 is not obstructing the police, which is what this is about. It's not about filming.
Hence, was that her willful intent, or was she just willful?
Just get back up here.
Because the whole freedom of the press does not, it's clear under case law that the freedom of press is not just Fox 5. It's every person who's trying to gather information or give information about public affairs, about things that are public interest. And that's what
And I watched some commentary on the case, and somebody was complaining he was claiming to be a member of the press. He said, well, that's ridiculous. But the fact of the matter is, he has 500,000 followers.
Even if, yeah,
500,000. That's more than circulation of the RJ, I guarantee.
Yeah.
Sure.
More than circulation of a lot of papers.
yes.
And so there has to be an outlet, I suppose, for those sorts of activities too, even if they're not Walter Cronkite,
And that's the thing.
Eduardo Murrow.
I think my issue is with the use of the word press, because I think he is a sharer of information. I don't think that press to me implies that it is
Real, like traditional. Like
yes. I mean, I would call him a vlogger. I would call
but
him.
That's the press, though. You
Is
give him
it?
that. Yeah, absolutely.
Yeah.
I mean,
Pat, I'm just muting this for a second. Pat, do you have any comment about the super chat here from Corn Nuts? Judge won't rule today. She will take it under advisement and rule after he's released.
That's always that's pretty common, but that's not necessarily what could happen. She could start out by saying, I'm going to tell you where I'm leaning. I'm going to tell you what I think are the main issues that I want you for the Castro to address. First is explain to me why there was no obstruction under Wilson. Secondly, tell me what constitutional words were actually issued that you think would merit a reversal of the charge. None of it was actually discussed in the appellate briefs, although they keep talking about it. Next, explain to me how the brief that you say me filed, 4-page brief with no citation, Ninth Circuit, how that has any way to change the outcome of the case. What? Why wasn't that more amplified and discussed in your appellate paper? You haven't really persuaded me. Next is, are you still holding? This would be a major hint. Are you still holding to the idea that the judge was biased? That's a serious charge, and lawyers are in trouble for making those kinds of charges. So she could just signal to you right away what she wants to hear, and the rest of it could mean that she's already made her decision on the remaining issues.
Sorry, gang. Of course, I've never had a problem like this with StreamYard. Chooses to do it today. I don't know. I just got kicked out for some bizarre reason. But here we go. You guys all hear me now again?
Yeah.
Trial
Okay.
witnesses have said testimony that was not true. Client control is real for defense attorneys. I don't have to tell you that. But
Stand by,
I think
guys.
what he did.
Share screen. Yeah. Yeah, okay, it's there. All right. Yeah, of course it does this today.
Here was it did not help his position in any way.
Well, it certainly got him more punishment,
Sure.
right?
Yeah.
But it also drove people to, I mean, I've seen the trial views. There was
for Christ's
something like
sake.
500,000 trial views.
Again,
Crazy.
Oh, come on.
So
I can hear it fine, Dickbag.
Yeah, that's everything.
Yeah.
the max.
She was, in my opinion,
Oh,
Zimmerman punished him for his behavior in the courtroom, not for his citation. Because how many times have you defended an obstruction citation and it has been 30-day suspended sentence, go take an impulse control?
Well, one of the most interesting things to me about this whole trial was Agus Botello, the prosecutor, asked for a 500.
Is it? Oh my God.
It's okay. They haven't started the hearing yet.
Yeah. Sorry, guys.
I'm looking at the nothing's been called yet. It's still with those attorneys or whatever, just debating each other.
Okay. Sounds good. Now, are you seeing the video on the screen? Because my StreamYard is like
No.
goofy.
No.
I'm not seeing it. All right. Okay. Sorry about that, folks.
Now you got it.
All
Now
right.
it's up.
All right. Yeah. For some reason, and this has never ever happened.
No, it started
every-
last night. I started having problems last night with StreamYard.
Yeah. Perfect.
And it went into today.
He did, and so he did not. But she's not stupid. She knows that he's probably surreptitiously recording. I think he was actually. If that's what I heard. Regardless, she wanted the marshal to hold onto his phone, which is appropriate because he is a chronic, surreptitious recorder. And he basically he gave the phone to the marshal. And he said something like, "You pig."
Yeah, or little piggy or something.
Yeah, something like that. But clearly insulting. That the marshal did nothing to this guy. Just doing his job, commanded by the judge. The judge obviously was not going to accept that.
Yeah, and in my experience, insulting court staff is about the worst thing you can do.
Absolutely.
It's akin with it had he said it to her. But where I have to give Judge Zimmerman credit, when she made her sentencing record, she made a very clear record for the basis for this maximum misdemeanor punishment. That I think if you look at it on its face will make it very difficult to overturn this on appeal because she appropriately justified it.
His behavior, his chronicness of he also has a pending case.
What she said, it was officer safety, and she was concerned about officer safety. Do you think that's honestly it? I mean,
for the sentence?
That's a tough question. I know what she said on the record.
Sure.
Okay. But I got a pretty good feeling what he's being punished for, and it's not for violating officer safety.
The question is this. I think the question is this. If you had a guy who was within 10 to 15 feet, because I think he backed up a little bit, if you had a person 10 to 15 feet simply doing this and got arrested for obstruction, would he get 6 months in prison? I'm sorry, jail. Probably not.
No. But also if you had a guy at 10 to 15 feet and he was simply doing this, does he even get the citation?
Does he even get contacted? I don't know. I think that I told you the aggression is going to be part of the calculus, right, for the officer, and I think that's fair.
And I think if you have the guy who's 10 feet out and follows the command the first time where the officer says back up and all he does is still stand there and do this, we never have this case, we never have this conversation, and have a who doesn't have 500,000 YouTube viewers, right?
No.
Because this is boring and this doesn't get clicks.
Anthony, you've done training for
Everybody.
decades.
Yeah, a couple decades.
A long time. I would imagine the training on how to handle these First Amendment auditors, these sort of things, has changed over the last 20 years.
Not only has the training changed, actually the training used to be non-existent. It's the officer's mentality has changed. I will tell you that, if you look back 20 years, officers were falling for these First Amendment auditor audits left and right. They were basically being, they're just falling for, literally falling for it because it's a trap. A lot of these guys like the cashier, they want to see these officers lose their cool
And engage.
And then
That's a good point there. From the discussion salon, Pat, are there any implications thanks for the £2, by the way. Is there any implications if Chille does win his appeal?
Can you hear me okay?
Yes, sir.
Yep.
Oh, great. I just got rid of the echo. I realized I'm not supposed to watch the video on YouTube while I'm listening backstage. So
Right.
Yes, there you go. You're clear
hard
too.
to focus
Your mic
with-
sounds good too. So, are there any implications if Chille wins?
All right. So let's suppose that he strikes gold and the convictions are reversed. If he's really serious, like he says about Terry v. Ohio, about deleting laws, then he would want to also have, first of all, the case is over, obviously, if he wins, but, the people could still appeal that decision as well. So I don't think this ends his battle. If he wins the appeal, there can be, if he wins this case today, there still could be an appeal by the people. And if he loses, he could still ask for the constitutional issues to be decided. So I don't really see a good escape route for him. The big issue for me was, would this be used as a springboard to overturn what I think are unconstitutional statutes? I have no problem with statutes that are clear, But the Wilson decision proved what I was saying months earlier, which is the way it's written, it has overlapping language. It uses delays and obstructs both for the resisting arrest charge and for the obstruction charge, which is really bad. And the Wilson court did backflips to try to keep from striking down the statute that was passed in 1911, has no legislative history, and was written in a different era. So, but I don't know that we're really getting there. But I do think today, if he loses, I think he's going to lose. The thing will be appealed anyway, and it'll be appealed for the constitutionality questions. And I don't think they've really been set up very well in the appellate briefs.
There you go. For all the people in the chat saying, you know, First Amendment. There you go.
Proving a First Amendment defense is difficult. And the reason is because defining the scope and the limits of words is difficult. You know, the idea about statutory interpretation would be you have to interpret it according to its plain language, its plain meaning. It has to be easily understood by the average person. Chille advocates
There we go.
constitutional law scholar, so therefore he would have heightened awareness and heightened knowledge, and that counts against him. But for the general public, my problem with it is, and this is from 10 years of criminal defense work, is the poor do not have the resources to fight back against a statute that, you know, is a misdemeanor and maybe relatively small jail time. Maybe
I got it starting on the other browser.
Oh, yeah. Okay. All
Judge just took the
Officer,
All
but
right.
he's not in any other way
All right. Let's
obstructing.
get up there.
Great.
Well, now they went back.
Good afternoon, everybody. My name is Scott Coffey. We are here.
Tell you that, you know, if you look back 20 years, officers were falling for these First Amendment auditor audits left and right. They were basically being, you know, they're just falling for, like literally like falling for it because it's a trap. A lot of these guys like the cashier, they want to see these officers lose their cool
And engage.
And then when I see officers like, and I'm not saying here wasn't right. I'm just saying in general, when you do see officers that don't bite the bait, you don't get any views, you know, or you don't see the video at all. But we do see, since about 20 years ago from today, you do see less and less officers actually engaging these people because they actually know that they're being played, right? That's really.
But that also rises to the level of going back to your hypothetical just a second ago. You have the guy 10 feet, 15 feet. He's standing there, and again, he's screaming the things at the officer, but he's not in any other way obstructing, or he's even 15 or 20 feet back, and he's standing there and still like yelling the obscenities. Again, being.
Yeah, appreciate the comment there. We clearly, well, I don't know what I'm talking about, but I think Pat might have a little bit of.
Yeah.
You might just have a little bit of education in this department and experience.
This goes to statutory interpretation.
Crime.
What do you mean by you? Are you talking about us, or are you talking about the three that are on the panel? You just wrote a very vague and ambiguous sentence, which would be struck down. Okay.
There you go.
But I will tell you what I tell my clients.
All right, so I guess he's stalling.
If you're antagonistic,
with this
you
video.
increase the chances of getting confronted, getting arrested, getting injured exponentially.
And they're human beings. I mean, just like Judge Zimmerman's a human being. If his behavior contributes to his sentence, it is what it is. It's part of being a human being, right? And people do have reactions to this thing. The one thing I'd like to address though is DeCascio was not just filming and being antagonistic. He was also engaging the driver.
I'm sorry, Pat. What did you say there?
I said the legal analysis here is roughly akin to Captain Obvious.
Yeah, gotcha.
It sounds like a law review article to me.
Gotcha.
Like, to me, if I stand there and yell, and unless what DeCastro was yelling was, you don't have to answer.
I'm assuming there's still stuff happening in the courtroom prior to all this starting, and they've just got the cameras fired up there, and they're playing this video just as a time killer, just so you know. So we're watching it as a time killer. So that's what's going on. If you've just joined or you're confused.
Yeah,
Go ahead, Pat.
we're actually seeing directly from our Nevada judges, because you have the rights to actually broadcast this or televise it, whatever word you're supposed to use.
Right.
So, you know, because I sponsored it, they gave you the rights to be able to show it, and so it's done with
Yes.
permission.
Yes.
And
Everybody, please give Pat a big thank you and a round of applause for making all this happen. Eternal gratitude for that. Amazing.
no problem.
Absolutely. I'm very honored for this honor. Well, there was a bad sense. I'm honored for this honor, Your Honor. All right. If anybody, Ram or Pat, you want to chime in, just let me know. I was planning on just playing the whole, proceedings without saying much, if anything. But of course,
Yeah.
jump in.
Like 5 feet or so away from her, maybe 10. So, right, I mean, there's something to be said about that, where the officer can say, hey, maybe it's not just my safety or my investigation, but it's also her. And he actually did say that in court that she had a right to privacy. Now, of course, we gotta be careful with that, right?
Sure.
I mean, but I know what he means. Obviously he's not a lawyer, but what he means is, hey, I got to protect. He did say something like this. I'm responsible for her, and he is.
Well, he's essentially saying what Castro said at the end of stop, which is mind your business, right?
Mm.
He got directly in the officer's face, mind your business.
Right, exactly. But it is his business.
Yeah, it's his business.
More than that.
That's his detainee. She is seized because of the officer's action, so he's responsible for her.
But she wasn't under arrest, so she's not a detainee.
Well, you know what I mean.
I mean,
She's detained. She's seized under the 14th
She's
Amendment.
stopped.
Yeah, she's not in custody, but the point is that he is still responsible in many ways for her safety and so forth. Now, I'm not saying
But there was nothing there at that point that gave rise to the level of that was a threat. Like to Castro with his phone in his hand isn't rising any alarms that there's an imminent threat.
Other than generically, everybody.
Doesn't have to be a threat
Sure.
for
Right, and I would imagine as an officer, you were trained to some extent to say the worst.
Yeah, and I mean, if Chille came up to me the way Chille comes up to people, I'd pay attention to him. I'd watch him very, very carefully. Yeah, that wasn't. Yeah,
anything's possible. It's just not probable. So we want to be kind of careful with that hyperbole and that we call it hypervigilance.
Sure.
And it can cause bad things.
But it's very interesting to me looking at the two different stops. The one that he was convicted for, the other one I think may still be pending.
Yeah.
The officers use different tactics, right?
Mm-hmm.
The officer in the case where he's convicted pushes back pretty hard. Get over here. You're going to do what I say. You're going to do this. The other officer's older, seemed more experienced. It was a vehicular death.
Is this trailer music behind it giving anybody else like anxiety? Oh man!
In my opinion,
he was really pushing it.
He was underneath the police tape, back outside the police tape, going into areas that he shouldn't be.
Yeah.
But the officer was much calmer about things.
Yeah.
They didn't listen to his mouthiness, which got to be hard.
Sure.
And nobody's going to say that's easy, particularly if you're out there by yourself.
Sure.
But it de-escalated in a very different way.
Yeah.
Just gonna mute this for a second, Pat. We do have a question for you there in chat from Richard Hillier. What do you think of Chille filing a motion for me to be co-counsel? He wanted to go pro se. He was denied, then me started the case.
Great question. This is the problem which happens when you share command. Lawyers do not like this because as much as some of these guys like Chille, who admitted, I don't think, not that it matters to me, if he came from humble beginnings and he doesn't have much by the way of education, that's fine. That can happen to anyone. Happened to my father. It's just the way it is. But that doesn't mean that you have legal training. And legal training is something that you learn from the School of Hard Knocks. I've had to make my mistakes as a lawyer in order to learn from them. And when he comes in thinking that he could be Mr. Super Lawyer Man in a criminal trial, well, he's taking away all the education experience that me has, and he's putting it on the side, and he's saying, basically rescue me when I get in trouble. That's a terrible idea, because then the lawyer doesn't know what to do because he knows what you're doing might not be right. Like me asked some brilliant questions on cross-examination. And even when he was, questioning Chille on the stand, he used very good words such as, he didn't call it, a clash. I think he called it inadvertent contact or something minimalist so as to minimize any kind of resisting arrest or whatnot. And Chille responded, well, he went hands-on, which now made it sound willful in a battle again. He did not pick up the cue by me that this was not supposed to sound willful, because willfulness will get you convicted. So, these are the subtleties that you learn from being a trial lawyer. And also, does he know when to object? Does he know the rules of evidence? I doubt it. Does he know how to ask the right questions without just getting a lot of objections sustained? So when he says, hey, I want to be my own lawyer, well, the judge has, I think it's under Ferretta, there's a questionnaire or some kind of a survey they have to ask the person to make sure they're fully aware of all their rights before they represent themselves, because they're going to be treated and held to the same standards as the lawyer. So it's generally a terrible idea. It causes confusion. Me looked very uncomfortable now assuming the role, because the judge was like, no, it's day of trial. You got a lawyer. He's licensed. I know him. He's going to take the case. And then it looked to me like me was forced to use the arguments Chille wanted to advance, which, again, may not be the ones that actually get the acquittal. So the problem is, when you say you want standby counsel, it's not like you can have a plumber next to you if you screw up and there's a leak, he's right there to fix it. Trials don't run that way. And so, I think it was a terrible idea, but this is what he likes to do.
Yeah. And Truth in Astronomy for $5. They're also overlooking the fact that Chille is red flagged as a possible danger to law enforcement.
Now, that won't be part of today's hearing because it's not part of the record. So it's important to realize that the review by the judge today is of limited scope. It relates to what's in the record. So if, like they said, if it's not in the record, it doesn't exist. And it's important that you make sure the record contains everything, because otherwise you could waive the ability to even discuss it.
There you go. Joey has a good point. Chille wore the wrong colored glasses frames. That was his downfall. Possible. You never know.
Yeah, those Sally Jesse Raphael glasses will never work in court.
Yep. Colors do have a psychological effect on people. Let's not forget. So there may be some truth in that. And then James wants to know where you get your suits from. Are they bespoke? He's buying a suit from Hackett, London tomorrow. Well, la-di-da.
No, they're not bespoke. I would need to lose some weight before I get to that level.
And then Misty saying, what about the lying that Jose did in the court filings, like him getting struck in the scrotum?
The testicular defense will not work very well today because it wasn't raised in the pleadings, and it would be a different type of claim. It would be more of a claim of a civil rights violation, which would be part of his 1983 case in federal court, which is subject to dismissal right now. So, and the court at this level does not impeach a witness except for an acknowledged impeachment, as they do not retry the facts. They do not weigh credibility. They just look at pure questions of law and think of them as an umpire. Was there a mistake made that would result in prejudice? Was there a mistake that would change the outcome? Was it harmless error? The no harm, no foul rule, like in basketball. So these are very limited proceedings, which is why the appellate papers is so important, because you have limited space to really write what you want to focus on. And what I found wrong about these appellate briefs was they were too scattered, too wide, and you're now getting into a superficial level of analysis when you have the burden of proof of overturning a conviction.
There you go. Yeah, any other questions, class? Yeah, this seems to be a good time. If you have questions, you don't have to super chat them either. If you have any questions, you want Pat to possibly answer, just put them in there. And while we're waiting for this to start, seems to be a good window to do that. So take advantage, kids. This man.
Well, these guys on the, sorry, Dick, I didn't interrupt you.
No,
these guys on the panel, I find them very, I don't know, shall I say boring?
Yeah.
And let's look at what would happen if I was Chen. He's going to be the guy arguing for the people.
Mm-hmm.
I've already got the win. Okay. Now, I've argued before the Court of Appeal several times, and it's not, which is bigger than this. This is, a step up to the district court, but it's not the Court of Appeal. And what makes it intimidating is someone, I got to remember what I say gets repeated.
Right.
All right, you guys are funny. All right.
That was the testicular defense was very funny. But
I have a
truth in
sense of humor.
yes,
I have a sense of humor. Nobody believes me except the people on YouTube, and some of them are skeptical too. Okay.
Truth in astronomy again for $5. That's true. If it isn't in the record, it doesn't happen. Yeah, very true. And if Chille will get free, said, I don't know. Yeah, we'll see how the partnership between Chille and Mr. Eline continues. We don't know. But it's all in the air.
I didn't know, by the way, that one Nevada judges was going to banner my name like this. I really didn't seek any of that. I'm telling you right now, I did not know. I did not ask for it. Alex will confirm that. I never asked for any of this.
That's okay. Yeah, it's appreciated, man.
It's a little embarrassing. You know, I'm like, okay, it's on the whole time. All right.
You're good. Salacious is, oh God, I got a lag with my things here. If he runs before his next trial, would the warrant be treated like Ohio? They don't try and get him unless he gets caught locally.
These are great questions. I love the word salacious too.
Salacious is one of our favorite people.
Yeah, and you know, salacious can get you into contempt an arena in a pleading, unless you know there are the cases that against that. What was it, Kanye West? The stuff that was written in the complaint against him was so over the top. I almost can't believe they filed it without filing it under seal, because it had all this, you know, allegations of, you know, conduct and whatnot. That was just, it really struck me as incredible that a lawyer would write all that stuff in the pleading and then file it and make it a public record, because it would shame and embarrass people. Now, at the same time, it's privileged under Civil Code Section 47. There's a litigation privilege is extremely strong, but at the same time, I could see a judge getting very angry with a lawyer, you know, writing something like that. Anyway, so salacious is, you know, an interesting word. Anyway, if he runs before his next trial, so we're talking about the one now in front of the chief judge and whatnot. In California, and again, I'm just a California attorney, I had an arrest warrant, a bench warrant issued against somebody that owed my client money. After I defeated them at trial, we wanted to collect on the judgment, and they refused to attend the debtors hearings that I had there at court. So the judge issued a $25,000 bench warrant, and I politely notified the other side of that, thinking that, you know, they needed to know that they're going to be arrested. Well, it turned out they never got arrested. The sheriff's deputies, while they were in court talking to me, I said to the cop, I said, you know, this guy's got a warrant. He goes, yeah, we know that. I said, well, are you going to enforce it? He goes, no, it's too low priority for us. We don't have enough space in our jails. So the sheriff could see there's a warrant and think of it as a low priority issue and not want to do anything about it. So I'm not sure about Ohio or Nevada, how they treat it, but at least in California, they don't seem to really give a lot of credence to it.
There you go. Cygnus bets on Chille. Chille will learn a lesson from all these. I don't think even Vegas would give you odds on that. And Rodent has a question for me, I guess. Does Chille realize he keeps arguing in the wrong arguments? Well, clearly not, from my view.
Yeah, he really, you know, the idea that he's being arrested for filming the police.
Yeah. And Chille, Tina, who has some very personal experience in this matter, says he won't learn a damn thing. And I tend to agree. Yeah, this is, we're just waiting, kids. So again, if you have any questions, Pat, we have a Shmuel, excuse me. Shmuel.
Oh,
Buckman.
okay.
You
All
at least
right.
one lawyer joke.
Okay, hold on a second. I've got some ready for you, and they're courtesy of the people that have been on my channel, very loyal. Appreciate that very much. Cicero Lipschitz, if she's listening, I'm going to have to give you credit, and also for another guy, he calls himself Edwin. They've been giving me a lot of lawyer jokes. So let me just see if I can entertain you with some lawyer jokes. Because do you know that there was an attorney at one time about 20 years ago that wanted to deem some of this stuff hate speech? I mean, come on, he got laughed out of the building, right? You can't talk about lawyers without being hate speech. I mean, this guy lost his mind. I mean, hey, you gotta be able to. Okay, here we go. All right, joke of the day. Now, I'm reading them. Okay, so they may not be good, but
You got to sell it, Pat.
okay. Well, I got to read them first. Then let me see here. This guy Edwin sends me a lawyer joke every day.
Maybe you should get one of those lawyer joke a day calendar.
Hey, Roundup.
There's something you could sell those. Pat. There you go.
All right, let me go to my channel and I'll read them to you. Hold on a second here.
Sure. Thanks for the $1.99, by the way, Shmuel. And we also have a $4.99 from Fraud and Roundup. What's up, buddy?
What up, bud?
Sheriff Wyatt and Moron. Hey,
Oh,
Pat.
is he there? Say hello to him. Hi there.
Yeah,
I love his.
he's got a question for you, actually, while you're looking for your jokes. How has Chille not gotten in legal trouble for practicing law without a license? Trifold. Then I've seen him try to teach a Constitution class.
Okay, so that is a loaded question. I don't know the answer as to whether or not it's called UPL here in California. It is a misdemeanor unless you've been convicted of it, and then it can be a felony the second time. California is very aggressive about UPL. California is a state unto itself. It does not like reciprocity, which means you just can't easily waive into California. I mean, there is some exceptions. I think DC, if you take the California bar, you can waive into other places, but I don't think you waive into California. I might be wrong, but I don't think you can. California is very protected. And so what constitutes the practice of law is a very factual question. And then opinions in and of themselves, is it rendering legal advice to a specific person? Is it a client and all that other stuff? So I don't know, because in all honesty, I've not read his trifolds. I really don't pay very much attention to him. I just really was looking at the constitutionality of these things. That's the only reason why I was interested in it. So I don't know the answer is the long-winded response. And so I don't know if he's actually running afoul of any of that. So I would be guessing, and I don't want to guess.
There you go.
All right, here's one.
Yeah.
A woman and her little girl were visiting. Oh, you know what? I told this one before, but I'll say it again. A woman and her little girl were visiting the grave of the little girl's grandmother. On their way through the cemetery back to the car, the little girl asked, "Mommy, do they ever bury two people in the same grave?" "Of course not, dear," replied the mom. "Why would you ever think that?" Then the little girl said, "Well, the tombstone back there said, 'Here lies an honest lawyer and an honest man.'"
I really wish I had a rim shot machine for you. I'll try and get one for the next. Got another one? Got another one?
Yes.
All right. Fire away.
Two fellows are taking a balloon ride. The wind is really strong, and they get blown to some. Oh, by the way, this is Cicero Lipschitz, so you got to love that screen name.
Absolutely.
Cicero, very famous name. And I did know a guy in my neighborhood. His last name was Lipschutz. So there was no I, but everyone called him that, unfortunately. Anyway, two fellows are taking a balloon ride. The wind is really strong, and they get blown to some unknown place. They are slowly descending onto a field and see a man walking by. They shout, "Excuse me, where are we?" He looks up and says,
"Whoop, whoop. Here we go. Hang on."
You are Chris Courtroom on behalf of the District Attorney.
Stop that music in the background.
If you want, you don't have to stand up throughout the whole hearing. It's up to you. Might be a minute.
If you have them, there we go. Here we go, kids. This is what it's all about.
You hear what she said? You'll be in the video. You might like that.
It seems that everybody agrees you have a right to film.
That's fun.
I'm not sure. I filed a lot of federal case laws suggesting we can film police officers, but the state doesn't seem to dispute that. In this case, you have a person who, for a living, this man for a living, that's his living, he films police officers. He has more than 500,000 subscribers. He is very, very famous as a First Amendment auditor. He's known as he testified around the United States and does this constantly. As I look at this case, there are multiple problems with it. It goes to trial, so let's start with what really happens. There's a letter written to the judge, and I cite to it, and you have a copy in the appendix. And the letter says this man's going to film the proceedings. The judge says, empty your pockets, suit pockets, all sorts of pockets, empty them. He says why, he complains it's a Fourth Amendment violation, you don't have a right to take my phone. And the judge also demands the defense counsel, turn your phone off. And she said, I don't want to be part of the truth chat. We already are. This is the starting point to this trial. And the state says, the court has a right to, keep the court secure. Absolutely, you do. Absolutely. Have a right to determine who's filming. Absolutely. But what was interesting in the state's argument is they forgot to mention that the court never looked at the prosecutor and says, hey, turn your phone off. Make sure your phone's off. It's all directed at him and his attorney. You can't take cell phones. You can't do that.
So this is the bias argument.
To do that. And it also kind of shows that the court had
officers of the court
towards Mr. Castro. Then, Judge, he makes a statement to the marshal. It's clear, not acceptable. The judge was agitated by it. Understandably so. As I look at that, I'm like, I come in these courts all the time. You don't get to call a marshal. So, I understand. That's a different matter. He's not on trial for calling the marshal a name, which you shouldn't have called. Maybe you could hold contempt proceedings for that. There are remedies that a court like yourself can do if somebody's being disruptive. Just because somebody's disruptive in a murder calls your court staff a name, it's inappropriate. I would realize with a client, oh boy, this is not looking good. But that doesn't mean you're going to find or suggest that the person committed murder simply because he's acting or she's acting in a fashion in a courtroom that shouldn't have happened. But it was clear then that the trial was going the wrong way. So when we look at the facts of the case, that the police officer testifies that this auditor approaches, says that he's a member of the press, identifies him immediately as a member of the press. I have video here. I also have exhibits. And that he wouldn't back up. Now at trial, that was commented on by the officer a couple of times. He wouldn't back up. He wouldn't back up. The prosecutor argued it. Then they started on the 21-foot rule. It's an imaginary rule. We all know there's no such thing as a 21-foot rule. It doesn't exist. But nobody was stopping that. Not defense counsel was saying, where is this coming from? What rule are you coming to with this? And the prosecutors argued, well, he's violating the 21-foot rule. There's no such thing as a 21-foot rule. And the state, to their credit, has abandoned and completely retreated. They don't argue.
Testify it was something he learned in the academy.
Yes. But I understand what it is, Judge, because I've used it myself in murder cases, and that is what they're argued that my clients are enduring is that if an assailant comes at an officer or a citizen within 21 feet, you won't be able to draw your weapon. That's what they're taught. So it's something that we use in a self-defense case. Oh, look, the guy was, coming, and so my guy had no choice but to shoot. I understand that's what police officers are taught, but that's got no bearing on this. There is no 21-foot rule, and in fact, we just go to Click. Click is a First Circuit and self-flag on. And in Click, I thought the language was so important to this case, because in Click, they begin speaking about that officers, in that case, versus filming on the Boston Common, filming from 10 feet away. That's very relevant because the police officer in that case said, Mr. Castro was 10 feet away. And so the First Circuit said that is 10 feet away. And then the First Circuit starts saying, police officers need to deal with provocative and challenging speech. They further identify that when a police officer comes in contact with somebody who's being rude or obnoxious, that they feel like they shouldn't be filmed, that they shouldn't have to endure that. And the First Circuit then goes on to talk about that officers sometimes retaliate because they don't like it. They don't like it. And they said that's what happened in Click. The officers didn't like it. You don't film us. You have no right to film us. Okay? And so when I look at the situation, I'm like, officers, we have a right to film officers. In fact, we have an actual statute on it. NRS 171.1233. This is cited in page 2 of my reply brief, footnote 1. Subsection 2, subsection A states, a peace officer shall not act to interfere with a person's recording of law enforcement activity, including, without limitation, by A, intentionally preventing or attempting to prevent a person from recording the law enforcement activity. You have a right to do it. We know it by statute. We know it by federal law. So what does Mr. DeCastro do? When the officer tells him, back up, I can prove he does. I've attached the exhibits. I don't, if the state wants me to, I'll put it up and I'll show it, but we can see from Exhibit A that where Mr. DeCastro is standing, he's standing in a particular parking space. We can see in Exhibit B, he has now moved back into the back parking space. I don't, when I say back parking space, I know that may be not a good record, but he's moving over.
Right, looks like it's in a parking lot.
Yes, it's a parking lot. He's moving from one parking space away. You can see it's away from the officer. So the state, to continuously argue he would not back up. Why are they doing that? Because they want to say he won't follow the command. And the accurate answer was, and I think the court would say, if you were asked to look at this case and say, what did Mr. DeCastro do when he was told to back up? He backed up a short distance. That would be fair. Maybe the court would not like that language, say maybe it's a few feet. But he did back up. What is not fair is he would not back up. He would not comply. He did not back up. And then the officer was asked, did you tell him how far? No, because he was disrupted. So I couldn't tell him how far. The 21-foot rule. There is no 21-foot rule. Click said 10 feet was fine. And in Click, what's more interesting about it is the officers, what Click is deciding is not like this court deciding whether there's criminal activity. Click is suing the officers. And the officers are over in federal court saying, oh no, give us qualified immunity. And the federal court said, no, not for this. You're not getting, for arresting somebody who's filming, you're going to get sued. You're not getting qualified immunity. You're going to have to fight this and go to a jury. I think that's very relevant because that's what's going to happen with this officer. Undoubtedly, you know he's going to sue, and I think he's already started that process. I'm not a civil lawyer, so don't do that. But I know that that is what's taking place. So what is hindering this man from obstructing him from writing his ticket? He can just simply write the ticket. He can look at Mr. DeCastro and think to myself, here's one of these auditors, walk over and write a ticket. He was asked the question, which I thought was really good at trial. He was asked, how did he obstruct you? How were you obstructed? And he said, well, I didn't know what his intentions were. I didn't know. Maybe he was armed. Well, that doesn't obstruct you. How does that obstruct you? That doesn't, he never gets in the way. So let's fast forward to Wilson. Okay? 3 weeks before this trial, the Court of Appeals considers one of my arguments here that the statute is unconstitutional, vague, and ambiguous. The Wilson court determines that the only way to impede, the only way that you impede is that you have fighting words or you physically do it. And the exact language of it is, we interpret 197.190 as applying only to physical conduct and fighting words. The court further explained that blocking the path of an officer may amount to obstruction. Well, that didn't happen. You can look at the video. There's no blocking. There's no blocking that goes on. And they also say that it could be non-aggressive, which made me curious. So I read the case. I thought, what could non-aggressive be? And it makes perfect sense. I would have never seen how non-aggressive could be obstruction. But what they then cite is they were pulling over an individual, police were. And then the guy who I guess is armed then starts to run for police. Well, now they've got to go chase it. So clearly they're hindering the police. So that made perfect sense, and that's the case they cited. What is interesting about Wilson is they also go on to say As construed by this court, NRS 197-190 prohibits only physical conduct and fighting words that hinder, delay, or obstruct a public officer in the discharge of official duties or powers. As such, law enforcement has no discretion to arrest persons for protected speech or for physical conduct that is merely annoying and offensive. Judge, I have no doubt I know you've watched this video, and I could see how anybody could look at this and hear the speech, get in your car, little doggy, and write your ticket, and find that to be annoying. I see that. But that's protected, and we've been told that's protected now by our courts in Nevada, by numerous federal courts. They went on to say the district court did not, so in Wilson was convicted, appealed, just like I'm doing here. And they point out in Wilson that on appeal, this court explained the district court did not have the benefit of our interpretation of 197-190 as being limited to physical conduct or fighting words, and therefore did not consider whether there was sufficient evidence that Wilson engaged in physical conduct or other fighting words so as to support her conviction, and the case was remanded. Why I think that's important is because one of sort of the big picture that I want the court to see that I'm arguing, I think Judge Zimmerman was put in an absolutely terrible situation. Here's look at all this litigation we're doing here. This isn't new. I didn't come up with, oh look, there's a new case that came out about a First Amendment issue. A lot of the cases I'm citing are 20 years old, 15 years old. This is known law. If we have this issue before you on a case, isn't it incumbent upon me to file this pretrial?
I wonder why that didn't occur in this case.
And the state says something interesting, which I understand the state's advocating. The state says that trial counsel filed a memorandum. Well, I'm like, it was comical. I understand what the state's doing. They're saying they need to try to protect their conviction. But the trial counsel, what he did is he filed some memo that right when the judge is making her decision, finding him guilty, she's like, what memo? And I filed them. She didn't read it. And then the state correctly, the state said, strike it. It's late. So what trial counsel does is, at the last minute, can you imagine I'm coming in here talking about the facts and all of a sudden I'm like, oh, Judge, there's a First Amendment issue. Like, well, don't you think you should have briefed that and let me know? And I hear the state's argument, and the state says courts are presumed to know law. And I know you know law, but I also know, Judge, that we get into issues. You've been on the bench a long time, so I know you know the law. But when, let's say we're going to talk about a Miranda or Messiah issue, I think that it's incumbent upon us to give the material to the court, let the state oppose it, let us reply so the court can look at everything, have the court's clerk go maybe find research that interests you on this so that you can make an informed decision, as opposed to at the very last minute in a factual trial, like, oh, by the way, there was a Messiah issue. I don't understand why he did that. This was the issue. This should have happened beforehand. This should have been litigated beforehand. The court, like yourself, just like we're doing here, we should give you the opportunity to go look at it. And maybe my rendition of it is not the way you want to go. It's the state's rendition. But the fact of the matter is, at least you had it, and Judge Zimmerman didn't. And that's ineffective because he should have showed the court these issues. And if he had, just like here, the Wilson case would have come up. I know it was brand new. It was only 3 weeks before the trial. But then the court could say to the state, hey, you've got to have physical conduct or fighting words. We can't just do this on driver safety. Because at one point, the judge ruled, because the prosecutor kept arguing, and the police officer testified, well, the driver had a right to privacy. Like, the driver doesn't have.
Drivers out in public. I don't know if
Right.
the driver had a right to privacy. When you're out in public,
You don't have a right to it. And here's another thing.
Interesting.
The state then comes back in their response.
Nodding her head a lot, which is a bad sign.
Yep.
And he cites a bunch of cases, every single case. It made me realize when I read it that they have real legal problems. They've got problems with the law. Because what I did is I read every single one of their cases. And what I found was, oh, this is not at all what these things stand for. In other words, in fairness, they were saying their time, place, manner restrictions. Yes, true, the cases did stand for that. But let's start with Philadelphia, Fields versus City of Philadelphia. Now, when I first saw the video, what came to mind, just jumped to my mind, was I looked at it and thought, hey, wait a second. Didn't those people in George Floyd, weren't they filming it with cell phone? Now, I hadn't really followed it that much, but I kind of thought about it and it ran through my mind. So I then started pulling up the exhibits that I put and I looked at it and I said, well, boy, those people are closer. They're closer than Mr. DeCastro. Another thing that came to mind is, although I didn't really follow that trial very much, I did remember the firefighter. She's an off-duty firefighter, and she came to court with her uniform on. It was devastating for those officers because she said, I tried to tell them, and then they started saying, if you were a real firefighter, you'd know not to get involved. And she said she started using profanity at the officers. And she, at one point, is within a foot of the officers. There's an Asian officer in the back of the vehicle. She comes very close to him. When I look at that, I'm like, well, how is she not in the same situation as him? She's admitting she's using foul language. And I remember her trial testimony where she was crying, and I think it was extraordinarily impactful. I want to talk about something for a second, Judge. Police have to deal with difficult people. I know that because I witnessed it in your courtroom. Right there, right back there, right by the door. And I seem to remember, I was in a capital trial, came up from a break, about 1 in the afternoon, and what I see is Officer Hawks having to deal with, I don't know if she's a homeless lady or what, sort of small Caucasian lady, but out of control, and I'm watching, almost nobody's in here, and she's saying horrendous things to Officer Hawks. He there comes back up, because I know there was a female officer, and they're trying to talk to her. Your marshal showed incredible restraint. I know that because I watched her try to kick him in the groin. She tried to kick him, and I watched it happen. And I don't think she was arrested. At some point, they did everything they could to just get her out of here. She was so obnoxious and abusive to your marshal, yet the restraint shown was remarkable. I remember that because I addressed it with Officer Hawks. How did you do that? To me, it was amazing that a human being could practice that type of restraint, and that's what he did. And that's what this officer should have done. He was angry. When the state says to you, and when the officer said, I was concerned for officer safety. No, he wasn't. At the point when he says to him that annoying language that we call, and the federal courts have said it, provocative and challenging, get in your car, little doggy, and write a ticket. First of all, he's telling him to write the ticket. He's not instructing him. He's just, it's like a directive. Counsel, be quiet and sit down. Okay, that's a directive. But you're not instructing me from being quiet and sitting down. He's telling him to do it. And so I don't understand how the state can argue when I can see it for myself that the officer was concerned for officer safety. When he says that, when Mr. DeCastro says it, you can see the officer just gets irritated beyond my God, you don't say that to me. He just comes at him. He doesn't pull a taser or anything like that. He's like, you're detained. And then he grabs him pretty hard. And he's trying to say, well, I'm a member of the press. I'm a member of the press. You can't do this to me. He tells him, call your supervisor. Don't do this to me. And he's like, he brings out 2 cell phones, so he's not armed, and you know what he is. And even the officer said he knew about First Amendment auditors, but didn't say that they shoot people, because he was asked that. He goes, I don't know if I said that. He was agitated. This wasn't about fear. This was about truth be told.
Point Webb.
This officer was agitated. And the federal courts talk about that. They talk about a lot of these officers don't want to be filmed. And I want to go back to City versus Philadelphia, or Fields versus City of Philadelphia, because in the state's answering brief, they question, why would you be bringing up Floyd? Are you bringing that up? And I realized the state saw, why are you bringing it up? I saw it was directly relevant to filming police. So since they cited Fields versus City of Philadelphia, I went and read it. And it starts off, so what that is that's an individual who's got concerns about unions, and they're filming in Philadelphia. And the court starts off with very, very, very interesting language. This is the Third Circuit. The Third Circuit begins their analysis
What's important to me is, why is the judge considering all this circuit authority?
Video of Los Angeles Police Department officers.
Yeah.
They continue to go on about about that. I cite that on page 4 of my
Philadelphia, all this other
This
stuff.
case
Hasn't
involves
rejected it.
retaliation. Individuals making recordings have also faced retaliation by officers, such as arrests on false criminal charges and even violence. And that's because they're recognizing this. The federal courts around the United States are recognizing that police sometimes don't show the restraint that Officer Hawks does. You know, if you're being filmed and you got some irritating person, sometimes when we walk out of these courts, we got press that are like, what just happened? Did your client just get convicted? It's like, yes. Did your client just, you know, they want to sentence him to death? Yes. And you have to be calm. I can't just grab people and do it. You gotta suffer it. Suffer it. He didn't stop anything. He didn't grab the officer. He backed off from the officer. Yes, maybe annoying. Yes, maybe provocative, but it is not obstruction. It's not resisting. These are trumped up charges. And that's what the cases show. They can't show you a case. Not a single case could they rely on to show this is obstruction or resistance. Not once. And in fact, like I said, I think trial counsel should have presented it to the judge beforehand. Then the judge could make the correct decision without even a trial. I think if the court had seen it beforehand and not being so agitated by calling the marshal a name, that the court could have ruled that this is clearly protected First Amendment speech. Judge, also, I believe that I've argued that this is a First Amendment violation to convict him of it. It's also under the Wilson decision in the case, federal case law we decided it is clearly arbitrary and capricious. It's being applied incorrectly, and the court did not have the benefit of the Wilson decision because Wilson remanded it to tell the district court you need to look at this. That did not happen here, and so that's a problem. I argued judicial bias. The state claimed that there was no objection. Again, trial counsel didn't object when phones started being taken, didn't make any kind of formal objection. But in Echeverria and in Gurry was my case, it's murder of an FBI agent, there was no objection. It was well before my time, but I do it on post-conviction. I handled it on post-conviction. And it was that the trial judge had been, the FBI agent who'd been murdered, had actually investigated the trial judge. And so they found that that was an implicit bias, and so therefore there was reversal. The judge should have recused herself. She should have realized maybe I should hold this man in contempt, do contempt proceeding, and send this to somebody else. She didn't do that. But I also think it was incumbent upon defense counsel to do a better job and inform her of that. And that leads into my last argument of ineffective assistance of counsel. And I know that on appeal it's rarely considered. However, I cited case law that is clear as day, and I think the court can already see why wasn't this brief? Why is this whole hearing not happening prior to the trial date? So that Mr. Chen or whoever, it was Miss Agnes Lexis, why did she argue this against trial counsel and let the court make a decision? Judge, under the circumstances, reverse is mandated. It just, in every different area, I think under the Wilson decision, I think under the Cliff decision, I think under every single decision. And so I just want to make sure, Judge, that I cover all my points before I turn it over. And that is, they say Mr. DeCastro was angry and hostile. No, this is what he does for a living. That's how he approaches them to see, can they handle it? I think in other videos, if the officer handles it well, like Officer Hawks, then he kind of calms down a bit. He did.
I'll object to that as facts that are not in evidence, speculation.
I'll withdraw that argument. And what other time, place, manner restriction? When to do this as an auditor, to do this?
Target parking lot, right?
Yeah, in daylight, broad daylight. When if it was a female officer, not that if it's a female officer on a lonely highway going up to Ely, and all of a sudden somebody's approaching at 3 a.m, I think that's a different story. That shows officers like, God, what's happening here? And it's fearful. Keith does it in the most common way. He comes up, I'm a member of the press, annoying, provocative, all of those things. But he's protected. It is one of the most, it is something that is sacred to what our system of justice is. And one of the decisions I cited said, this is the difference between us and a free society, where we can go up and be obnoxious to police. Hey, I see what you're doing. I remember from the time I was in law school, I cite the case, but I don't wonder if you remember, Mr. Chen remembers it, where somebody comes up to an officer and calls him up, which I think is really, I remember as a law student, you shouldn't do that, that's bad. right? But the reality is, I then learned from the Supreme Court, it may be bad, it may be obnoxious. If it's your child, you'd be like, what did you say? But it's protected. It's protected, Judge. And he didn't do anything to violate or have those protections taken from him. I'd ask that you guys.
Thank you, Your Honor. First, I'd like to thank Mr. Oram. Considering that our response was called comical, I appreciate the nice words from him today. Regarding first and foremost with the ineffective assistance of counsel claim, even if counsel could have done it, we're still focusing on the prejudice problem. Ultimately, we're here, and this is the appellate court for this matter, so this court's going to make a matter of law decision. So I think ultimately everything regarding that issue gets resolved on a prejudice problem, whether or not Judge Zimmerman was surprised at the information that he wishes to put forth today. Now, with regard specifically to the First Amendment claim, Mr. Oram mentions that we cite to a number of cases, and the cases factually don't support our position, and I think we recognize that in our brief. There are cases where police officers have stopped individuals from filming encounters that they absolutely had a lawful right to do. This is why the court consistently talks about time, place, and manner restrictions. We don't doubt that that's the case, but to suggest that we didn't read those cases, I think it's an unfair characterization, because what we're trying to focus on is whether the time, place, and manner restrictions were present in this case. Now, what I would argue, and what I think we argued in our brief, is cases like Glick are relevant to the extent that in that case, the individual clearly was not impeding, obstructing, or being a problem to police officers. The only thing that individual in Glick was doing was filming officers, and the officers were upset by it. That's a very different situation when we're talking about time, place, and manner in this case. Yes, it's in a public parking lot, but you have to realize that as the facts came out, that the officer was letting the individual film until he approached the driver. Now, I agree, privacy is not a thing necessarily in public, which is why we didn't argue it. However, there are other concerns for time, place, and manner regarding safety of everybody involved, including the fact that when the officer is writing a ticket, when the officer is communicating with this lady who's been pulled over, when that lady is sitting in her car, free to move because she's subject of a traffic stop, that the scene needs to be secure. Now, I appreciate that the individual, Mr. Castro, could have plenty of followers, and he might have followers. I didn't know of him before this date, and it doesn't appear that the officer did either. So ultimately, the officer is treating this individual as someone who's filming, but doesn't know what the ultimate motivations are. It could be to film, it could be to do something else, it could be to interfere with the driver, and I think that's what the evidence shows in this particular case. Not only did he approach the driver, the key part where the obstruction begins to occur is when the officer asks him to back away from the driver. He says, well, I'm a filmer. Great, you can film, but I need you to back up. And again, we're quibbling over how much the back was, but
He barely backed up.
he backed up a couple of feet. There's no question about that. But I think what the officer testified to was he wanted it a further distance based upon, in large part, how Mr. Castro was operating. Now, if Mr. Castro had backed up a number of feet and continued recording and wasn't saying and doing the things that he was doing, I think we'd have a very different situation. But the problem is,
Mr. DeCastro's supposed to know that he has to back up further.
the officer instructed him in the video that to continue backing up, and rather than backing up, he stood his ground and said, no, I'm relying upon a fictional 10 feet rule, which I don't think is a matter of law. I don't think the First Amendment says 10 feet is automatically permissible, because you can do a lot of things.
There are courts that have held 10 feet is sufficient.
Depending on what the situation is, all right?
I agree.
If I pull out a gun, is 10 feet still sufficient? We're an open carry state, for instance, so there are individuals who can carry guns. So if we were to say automatically that I'm 10 feet away, and that as a matter of law, that's sufficient, I think it's very different if the individual is doing certain things. If the individual has a grenade in their hand, that's why it's time, place, and manner specific. We're not advocating, I didn't advocate for a 21-foot rule, even though that's what the officer said he was trained to do, in that the individual to back a certain amount.
He never vocalized that.
Yeah.
He never vocalized, said, hey, I want you to move 20, 21 feet back. Go back to this line. Don't come across this line. There was none of that because it happened so fast. I mean, the officer testified it was within like 10 to 15 seconds.
Yeah, it's all on the video as well, Your Honor, so I agree that he doesn't give a specific number.
Uh-oh.
And even if he had given a specific number, it's not that that specific number is somehow constitutional or not. But the point is the manner
And Chille said no twice.
Who's unknown to
Backing
the
up.
officer is interacting with that officer in that very manner is what the issue is for us. And based upon that, the officer can't continue to feel that he can do his job, the traffic stop, speaking with the individual, of doing any records checks that need to be done, of writing the actual ticket, while this individual is yelling, refusing to move back at a further distance, and again, with unknown motivations. In hindsight, we can look at him and perhaps say, well, he was only here to put this on his YouTube channel. But ultimately, at the time that it's happening, this officer who interacts with him, who even tells him, you're film, and he can continue backing up, I think that's what the reasonableness is. That's what the time, place, and manner restriction is, not some magical number. As we point out in our brief, I think what Mr. DeCastro believes and what counsel believes is that because Blake said 10 feet, that there's this line of 10 feet, and no matter what, I can do whatever I want within 10 feet. And I think even Wilson, although I understand it's remanded for further hearings, goes against that proposition that, oh, there's some type of magical number or anything like that. This individual in Wilson is yelling as there's a suicidal individual who obviously a delicate situation. The police don't want this individual to hurt himself, and Wilson continues to yell and interfere with what's going on. Specifically in Wilson too, that even though they say physical conduct again is made up of multiple.
Good. Now he's arguing the exception.
What we do with our bodies, but as well as what we're saying and how we're acting throughout the course of the interaction. And Wilson acknowledges that. In fact, they cite a treatise, what constitutes obstructing or resisting an officer. And if you look at that particular treatise, I mean, it goes on for multiple pages of various conduct that would entail obstructing. So here, it's not simply about the words. It's not simply about the fact that Mr. DeCastro was annoying. It's not simply about the fact that Mr. Castro was saying things like calling the officer doggy and whatnot. It's not about that. It's the totality of the circumstance which prohibited the officer from being able to safely and adequately conduct the traffic stop. And that's.
Well, he immediately released her.
He did.
Also, I mean, he gets out of the car. I mean, it appears to me he was going to release her regardless because it was so fast. He said, "You're free to go," and then he
This is really going bad.
take care of the other
Yep.
issue.
Yeah, well, I mean, what we have in this particular one is he went and did the records check, and then he mentioned too, she was surprised or even confused by the fact that she had an issue with her registration. Exactly. Now, again, I don't want it's speculating to assume what happened there, but certainly those are the facts that came out at trial.
He needs to say that DeCastro refused to back up and said he wouldn't move any further. No,
Yeah.
Obviously, he pulled her over because the system,
Yep.
as he testified, said that.
he's getting into semantics over distance.
But because
The
of the
trap
fact
worked.
that this all went on, perhaps the obstructing was that he didn't feel comfortable to write. It wasn't worth writing this ticket. She already was informed of it so that he could deal with this other situation of this individual who's clearly obstructing with his ability.
That's the problem when a guy
to get to
argues
the
it.
very end of
tries
his
to
investigation, whether he was going to release her or whether he was going to write the ticket. The problem
Floundering.
is the impediment is the individual who's continuing to yell and stand a number of
You
feet
could
away.
never do that then if all the officer had to do was say, because I had to go deal with this, I couldn't write the citation,
Uh-oh.
right?
I think it's time, place, and manner specific though. In this particular case, when you watch the video, I think he is that much of a problem that this officer ended up, talking to him more.
But what's the obstruction? It's not the words and it's not the filming. I mean, the officer, to his credit, he said right away, you can film, you just need to back up, and I understand he didn't want him talking to the driver, but it didn't appear to me as though after he was instructed, don't talk to my driver, he didn't talk to her anymore. Is that accurate?
That is accurate, yes.
Right?
And everyone testifies to that.
Right, and then he backed up. I mean, I understand the officer didn't think it was enough, and so, I mean, is it just that he didn't back up far enough for the officer? That was the obstruction?
He didn't back up far enough in addition to the manner in which he was acting. So had there been a
This guy's
conversation
talking in
saying,
conclusory
officer,
terms.
and again, everything is so fact specific, right? But the fact that DeCastro is immediately yelling, arguing with the officer about the amount of backing up that needs to be done, that's what the issue is. It isn't about the space in itself or the distance in itself. It's a combination of factors of everything involved. Now, Mr. Oram says that depending on who the officer was and where it was at night, I believe where it was could play into it, but I think it's an unfair statement to assume that some officer, simply by virtue of being a female, would somehow be in an incredibly worse position. Mr. Castro, for instance, could treat her differently or would need to treat her differently than the officer that we have involved here. I think.
Well, if it was in Ely on the side of the road at 3 a.m. on that road between
for any
Reno and Vegas.
Yeah, for any individual, I would agree. For any individual.
I agree.
I'm just saying that it seems incredibly sexist to say that some officer.
Who cares about sex right now? You need to win the case.
Male officer would be automatically good to deal with the DeCastros of the world who want to.
That argument was never brought up in the papers either.
Wholeheartedly agree with the characterization there in terms of the time, place, and manner.
I think against the obstruction
road
right
could
now.
be a factor, but they're all just factors. This case has its own facts. There will be other cases that come through the line, but I'm just arguing that pursuant to these particular facts, he was convicted of obstructing. And Mr. Warren doesn't address at all that second issue, which has to do with the resisting portion of things. Now, I think the case law is clear.
That Lisenby case. I mean, so even if, let's say, even if I agree that this wasn't obstruction, it was unlawful to detain him, that Lisenby case seems to indicate he still can't resist.
And that would be our argument. He hasn't addressed it, I'm sure he will on his reply, but that's the last of my argument. Thank you.
And I'll address that. First of all, I didn't mean in any way, Judge. You could take the biggest male officer. I meant just giving the scenario. It could be 1 in the morning, 3 in the morning, female, male. I didn't mean it that way. I just meant the visual of how it's different there. What I just heard was sort of interesting. Mr. Chen just said, I didn't argue the 21-foot rule because it didn't, it's not applicable. They sure did it drop, didn't they? That's what they argued. Even a prosecutor argued it. So Mr. Chen is only retreating from it because it's not a rule and it makes no sense. It's something used, as we talked about, in self-defense type issues.
But if the officer would have said that, I'm not sure that would have been unreasonable.
I
really want you to be about 21 feet back, give me some space, and don't go past this white line. I mean, there were markers in the parking lot.
Right. And if he had grabbed his citation started and Mr. Castro got in the way, you're not going to do that. It's obstruction. This is an obstruction. And the 10 feet, I agree. Is it 10 if you're only 9.5 feet? No, I don't think that's the point. The point they're trying to make is that our statute tells us we can film police officers. It doesn't say 10 feet, 21 feet, it just says filming them. When he was told to back up, he did. And the state is now saying, yes, we all agree with that. We're quibbling over words. I'm only quibbling over words because they kept saying at trial he wouldn't back up, which is not quibbling with words, it's inaccurate.
That's true. I mean, the officer did testify in direct examination repeatedly that he didn't back up.
Yes.
But on cross indicated, well, he did back up, he just didn't back up.
Substantial.
Yeah, he may have backed up inches, he didn't substantially back up.
Now, with regard to what are the intentions?
That means the judge did see the video, but did she see all of the right video?
Right.
Because I think there was testimony that I don't know who this guy is connected to. You don't know who this person is. Well,
remember in the video I showed the intro where he refused to back up and said no twice.
They didn't know it was an off-duty firefighter. They probably had done something different if they knew what they were dealing with. But they didn't know, and so the same arguments could be made. Oh, they're within 10 feet, officer safety. Maybe those are all gang members, and they're the same gang as George Floyd. It's his brother, so that won't be sexist. It's his sister who's gonna pull out a gun, or some other person, male, female, gonna pull out a gun and shoot it. So we are doing this for officer safety. No, it isn't. And the courts, you can look at George Floyd and realize the courts in a big case in the United States said, these people have a right to do that. And the question I really ask, I think is important. There was no abuse. The officer wasn't doing anything abusive to the driver. It's clear as day. Okay? What if he was? And he caught it on film. And now it's hitting CNN and Fox and all of this stuff. Then they say, oh yeah, we caught him, and 10 years from now, the Third Circuit's going to be quoting what he did. But he didn't catch them. So is that the standard? Can we film police officers? But if they're not doing anything wrong and I'm using obnoxious language, then I can be arrested? Is that what the standard? It isn't, Judge. The application.
You're allowed to be annoying.
I'm sorry?
You're allowed to be annoying.
You're allowed to be annoying.
Oh, man.
You're allowed to be obnoxious.
Yeah. And I realize we as lawyers appear in front of judges all the time. We appear in front of juries. We're trying not to, want to be obnoxious. It won't help your case. It won't help that. But I recognize this is some cornerstone. It's a foundation of our nation. The resisting. Did you notice the officer said, when this resisting is happening, my body cam all of a sudden doesn't go out. He testified he never resisted. And you can see it on him. He tells him, don't do it. The officer really grabs him hard. And then he's like, okay, I'm walking. You even see him with his camera. I'm walking back to your car. There's no resisting. He's trying to tell him, you're being unconstitutional. He does say it. You can't do this to me. Call your supervisor. But they get him in handcuffs, and there he sits. By the way, the state didn't ask for him to sit there. Agnes Lexus asked for a suspended sentence, and Judge Zimmerman decided to give him the maximum. He's been in there 4.5 months for this.
You didn't give them
Right,
that.
so that characterization it's not a maximum. It's 3 months on each count consecutively.
Right, yeah. It's
Oh,
with
you're right.
the
Okay,
maximum.
you're right.
Oh, man.
I stand corrected.
You guys finally speaking up. It might be too late to say the obstruction charge.
But the
I
state
think it
didn't
is.
ask for that. They asked for concurrent 90 days suspended. It goes to show what really happened. There were so many different errors. And I can tell the court has a good handle of this. Judge, there is no resisting. It was an unconstitutional arrest. The man should receive the benefit. I mean, we have a beyond reasonable doubt standard. We can look at Wilson. I now hear the state really struggling. They almost sound like me in a bad murder case where they're saying, well, what is physical conduct or contact? Because that's what Wilson said. And they're struggling with it because they don't even, because there's no physical contact. Backing up and filming and then pulling out a second camera, it's not physical conduct. There's nothing physical. He doesn't do anything physical. The officer just lost control. And he was irritated. Maybe we understand. It's not.
Yeah, you can understand. I can understand.
Okay,
And
yeah.
it kind of comes out of nowhere.
It's out of nowhere. It's who wants to be called names? But that's what the courts are all saying. You've got to endure this. Our citizens have a right to do this, and it also keeps our police. These auditors do help in some way because sometimes improved police are.
Wow.
If there was an auditor on what he did, and that one was like, oh, he was saying these things to me. No, he wasn't. If I'm not a witness to it, no, he isn't. And the video shows that if somebody was filming it, he wasn't doing anything wrong. So some false allegation by some crazy lady, okay, it helps them sometimes. And also sometimes it catches bad police officers. Here, what we have is a situation where you had a right to do it. And so for those reasons, I ask that you grant the appeal and reverse this man's conviction.
Anything else on the state?
I would only briefly say that in the Floyd case, no one was arrested.
Oh.
That's what the distinction is there.
Wow.
So people were
Floyd.
not filmed in
Argue the
camera.
exception to
Obviously,
Wilson.
other things happened from that case, but the issue is not that they were filming, that no one was arrested there. And the case law makes it clear in Lisenby and other ones, if there's a probability of substantial harm or death, then individuals can actually interfere and wouldn't be obstructed. So the case law, I just want to point out that distinction, but otherwise I have nothing else.
Okay, so this time the court's gonna grant the appeal and reverse the conviction.
Oh, my God.
Based on its First Amendment protected conduct, and Mr. Orm, you can prepare the court.
Yes, ma'am.
Wow.
Thank you very much, Joe.
Wow.
Wow.
To be released.
Oh, my goodness.
Wow.
Oh, man.
Thank you.
Oh, geez.
Wow.
Oh, my
Holy
goodness.
cow.
I did not see that coming.
Nope.
That was I will say that was a terrible job of presenting the appeal. Absolutely terrible.
No,
I
Yeah.
I got to give
Chille,
Orem credit. He pulled it
that
off.
is an arrestable offense. I'm sorry.
he almost got arrested again. Wow. Well, yeah, that Orem spun that guy out so hard, and he even called attention to it. Look, he looks like a deer in the headlights. But well, welcome everybody from our Nevada judges. We're here with Pat Darcy, attorney at law, and he's going to give us some thoughts on what just happened. Take it away, Pat.
I am absolutely shocked. You know me, I didn't think he would win this appeal. I thought initially the obstruction charge was very iffy. However, the Wilson decision had a specific exception that the guy here arguing for the state never even brought to light. What I thought happened was he allowed Orem to, and Orem did a great job. First of all, he got the reversal, so he did a great job. But this was insane to me because, first of all, they never mentioned the DA here never mentioned that in the video there were two instances where the cop told him to back up and Chille said no. So if that's not obstruction, I don't know what is. And he also has diverted himself away from the driver, even though he released the driver right away. But it was the non-compliance at that point where he was refusing. So Orem skillfully redirected it to, well, maybe he didn't back up enough feet and it was so quick. What can we do about this situation? Which was a great argument, but the facts were different. The facts is that, he cussed out the officer, which would be constitutionally protected speech. So that's true. But this guy arguing the appeal, I mean, he seemed too generic to me. And that's the problem that happens when the trial lawyer is not the one arguing the appeal. Sometimes they don't do that, but I got to give Chille the credit. He got the win, but I think that this was really a gift because, when Chille is refusing to cooperate, he's already bringing himself into this problem. And so, hey, it is what it is. So he gets the win. I have to tip my hat and give it to him, but I think this was a terribly argued appeal by the people.
Yeah.
No
agreed.
argument.
Yeah. I think that, like I was saying, Orem was just batting that guy around at the end there. He even said, look, he's spinning. He pointed it out to the judge. But as you noted, Pat, the judge was immediately sort of nodding along with Orem, and didn't raise any questions while he was talking, whereas she interrupted the prosecutor several times, questioning him. So it seems to me this was like, now he mentioned a Messiah issue. Can you explain what that is? Because I for one don't know what that is.
I couldn't hear all of it because of an echo. So let me just go over my thoughts right now. First of all, I don't know why the prosecutor wasn't objecting to out-of-circuit authority such as Glick in Pennsylvania and stuff like that. Now, maybe the Nevada lawyers can correct me on this. California has a very dim view of citing to out-of-circuit authority. And, one person who, I wasn't sure if he was an attorney or not, he said that Nevada is pretty wide open and they allow that. Okay, I don't know that to be true. But I would be putting Orem to his test. But the problem is the people were also arguing a lot of out-of-circuit cases. And here's the thing. First of all, they never mentioned the Heibel decision, which I showed on my video, that said the resisting arrest charge was constitutional. They never argued about how on the Wilson decision, there is an exception to physical conduct and fighting words. And the exception is, as I've said all along for months, is passive-aggressive conduct. If you act passive-aggressive, you'll be pulled into the bucket of physical conduct. And Orem skillfully avoided mentioning the exception. The prosecutor never really brought it up. I thought he was, and he didn't. And then he allowed himself to get taught into this dance with Orem about what Orem's arguments are. You don't do that. You go for the kill, okay? First off, Judge, the cop said twice, Chille said twice that he wasn't going to back up. If that is an obstruction, then what is? It wasn't one time, it was twice. And the cop had a right to keep this guy away. Now, the cop said on the stand that officer safety was the issue, but he also said that he didn't think that Chille was a threat. So I don't think that officer safety really was the controlling point here. So that doesn't matter. Privacy was important because he's filming an encounter where the cop is handing over a driver's license insurance information. And this lady doesn't obviously want this information to go up on YouTube for one of his videos. And so the officer had a concern for her privacy. He didn't know who Chille was and why he was there. And he didn't just say, go back into your car, like it was a cooperative thing. He was saying it defiantly. And secondly, he told the cop to go F off, right? And then when the cop said, I'm going to detain you, Chille continued to say, no, don't put your hands on me. Now, at that point in time, is that resisting obstruction? I'm going to say that it's not resisting because the cop never said anything about detaining him for resisting. He said just strictly obstruction. So none of that was brought up. I don't know if that's something that the judge even considered. That to me would have been the obstruction, was the delaying that is actually part of the Wilson decision. Heibel and Wilson both said the statutes are constitutional, okay? So the DA had the winning argument right there, but they never cited Heibel. They never even brought it up. I'm the one that brought it up. He's clear he never saw my videos on it. So right away, that was never discussed, okay? Next, you don't really care so much about what the other side is saying if it means not getting your arguments out. And I never saw the prosecutor stand up except for twice to say, wait a minute, that's not true. Like when Orem said that the judge gave max sentences, that's not true. She gave mid-range sentences. I'm glad he spoke up about that. But you got to control what the other side is saying, because what if they're saying things that aren't accurate that hurt you? Next, in terms of, whether or not Chille can be annoying, of course he can. Anybody can be annoying. The judge understands that. We all understand that. One of the things that we all talked about was, is there a magical rule that says how many feet you're supposed to back up before you are no longer interfering? And just like Wilson says, there is no law that can be passed, no statute that can be written that can encompass all situations. I just feel like the prosecutor here just didn't know the details at a very granular level, didn't know the case law. For example, ineffective assistance to counsel, they never said, well, wait a minute, show us, Judge, how that 4-page memo that me filed would have had any effect on the outcome of the case. Did you hear him even argue that? I didn't.
No.
And did you see anywhere in the appellate paper, the opposition, the responding brief, where they showed as a matter of law that 4-page memorandum that cited a 1/9 Circuit case would have had any effect on the arguments that they were making themselves? They also never said what speech specifically was unconstitutional. None of this was covered, okay? You're giving the other side the win, all right?
Yeah, it was theirs to lose. I mean, that was a huge whiff on that. I noticed he was just standing there arms crossed through most of it, not really taking any notes, not really, and so I was thinking, okay, either this guy's got an ace in the hole and he's not worried, or Chille's going to win.
Well, I saw him go for the water bottle twice, right before, in the middle when Orem was speaking and just before it started. And that is usually a sign of excessive nervousness. Okay.
Yeah.
And Orem was not nervous. He's battle tested. Yep. He earned his pay today. He did a great job. I mean, he got his message across. This was arbitrary. This was capricious. There was no way that Chille should be busted for this because the cop overreacted. Oh, and the judge was angry. Did you ever hear the prosecutor mention that the judge's rule applied to everybody about turning over the phones? Did you ever hear him say that? And did you ever hear him say how he disobeyed the marshal's earlier rules about filming and the phones? I didn't. And there's an automatic right that you surrender when you go into a courtroom, that the judge has control over it. And it was a rule that was applied to everyone equally, except for the court officers, which would be the two, the two DAs and the defense counsel. But that's normal. So to say that the judge is biased simply because she doesn't want him to secretly film things that he admits to filming, is not a deprivation of his rights. It does not show bias. It shows a judge enforcing the rule that she enforces against anyone at any time. So Orem skillfully turned that into a bias move, and the prosecutor had no response to that.
Yeah.
A major mistake. A major mistake. And to say that, me was ineffective, did you ever hear him talk about how me is the lead counsel in the civil rights case? Or that me's name appears on the notice of appeal? How ineffective can he be if Chille is still working with him?
Yeah. Well,
did you hear that being argued?
Chille was definitely the beneficiary of ill-prepared prosecutor here, and I guess all that fundraising he did for the lawyer paid off in the end, because that kid took a shellacking. Orem really made mincemeat.
You know what happens is sometimes, and Orem himself, I thought, made a tactical mistake when he didn't reserve any of his time, but it sounded like the judge said you're out of time, because usually they give you a time limit for oral argument, and he still went anyway and still argued a rebuttal. This is a guy that's going for the win, okay? That is trial experience. And I don't know, I'm not saying that the prosecutor doesn't have trial experience. I'm just giving it my perception here. I would have objected to all out-of-circuit authority. I'd say, wait a minute, Judge, what basis does this court have to listen to a case in Philadelphia? We're in the Ninth Circuit. Why does that matter? Also, Judge, what authority from Nevada does he have that cites that the arrest was unlawful? He can't point to it. All he can point to are two statutes that have been declared constitutional by a higher court, and the reason was officer safety. Did you hear him argue any of that? The other side?
Nope.
The Hibble decision, which I showed on my video that I found, I think it was 2002, said that officer safety will be the reason why we will break from the Ninth Circuit. Officer safety. Now, the cop said officer safety. Now, we know that that's kind of a flaky determination at the point, because the cop said privacy when he initially interacted with Chille, but that doesn't mean that privacy is the only thing on the cop's mind, okay? Right. That doesn't mean just because he doesn't say it that he's not thinking about it. So, Again, I think that this was astounding. I mean, listen, I'll admit, I predicted a very massive defeat today, but I'm going to put a little bit of an asterisk next to it, because I didn't hear any of those arguments coming out, and all I heard was Orem basically painting a very unfair picture of what happened to Chille, and the prosecutor kind of talking in generalities. And he'd say, well, he sounded like a guy that was doing a law review article in some ways, Well, there's this. No, you have to go in with your arguments, and I didn't see them well honed. And again, not even mentioning the exception to Wilson, which is the obstruction charge. That leads to everything else,
Yeah.
I mean,
ill prepared, I think. Yeah.
I'm gonna have to say it. Orem delivered.
Yep, he sure did. Mel, thanks for becoming a new member, and Archangel Azrael. Thanks for being a member for 3 months. And then this leads to Edward Wildehane for $2. This is a big question or a statement, but it leads into this next part. If Chille loses, he's going to sue. Yeah, well, he's already made that. We knew that. That's a foregone conclusion. But he definitely is now. And Chille used for another $2. Edward, Chille used the Chewbacca defense. If you can clarify that in the comments, I'm not sure what that is. But
let me interrupt you real quick, Dickbag, on the suits. If Chille is going to sue Judge Zimmerman, then first of all, he's going to lose on judicial immunity, because anything, at least in California, I'm speaking from a California perspective. Let me make that clear. I'm not a Nevada lawyer. I'd love for the Nevada lawyers to chime in and tell me, is there an ability to use out-of-circuit authority to support the appeal that happened today? Because if I was a prosecutor and I came back I was in the prosecution's office, we do want to win these cases, right? And if it goes up on appeal, you would expect right now that the prosecutor, I want to say his name, I know his name, but I want to say it, is going back feeling completely sunken. He's feeling horrible because he was supposed to protect the win that was obtained at trial. And Now they got to figure out what are their options. Is there an option to appeal this decision? Procedurally, I don't know how they do that in Nevada, and I don't want to say the wrong thing and then, start a problem there. But, maybe the appeal at this district court level is final, except for questions of constitutionality. And if she's saying that she thought it was unconstitutional, that might be their only avenue to try to reinstate it. Okay. I don't know. It's obvious here. The rules in Nevada are very different than California. But next is the civil suing the judge. She, at least in California, has full immunity for everything she commands from the bench. I've even seen the cases on that. So that would lose. California has the anti-SLAPP statute 425.16 of the CCP. There's sections E1 through E4, and matters that occur in a judicial petitioning the government, all that stuff is under E1. Complete immunity, at least in California. He would lose and pay attorney's fees. Secondly, this is an interesting outcome because the judge in the federal case said that there was probable cause for the arrest. But the judge here in the civil case is making a different decision. Okay. A really huge point, I might add.
Wow. Well, so I think that answers Goddess of Truth's question.
Right.
Will this have any effect on his civil cases? Well, there we go.
I mean, the standards of proof are different. Now, listen, remember, beyond a reasonable doubt is they have different gradients. Preponderance of the evidence, 50.1, just a little bit more than the other side. Then there's clear and convincing, right? Then beyond reasonable doubt is higher. And clear and convincing is pretty high. It's like 75% in some ideas, people's minds. Those almost, it's clear that it happened. And I don't like using the word clear. So the standard in the civil case in the federal court is lower than the standard here in a criminal case. And in the criminal case, Chille now has prevailed. Okay. But would that really matter? Because the standard of proof is still lower in the civil court anyway. But it is great to use, and guess who will be handling the remainder of the civil case? The lawyer they declared incompetent, Michael Mee. Think about that. Think about how illogical that sounds. They're coming into court arguing Michael Mee is ineffective and he messed up. Yet he's the lawyer spearheading their civil rights case.
Man, yeah. William Graver for $2.
Do you think the judge is aware of any of this?
Who knows? I mean, I don't know. William's saying for $2, if Chille sues for loss of income, cue the IRS. Yeah, I don't. Boy,
I don't believe any of that.
Yeah, I don't know.
My interest in him is purely on the constitutional questions. I thought that statutes themselves were unconstitutional. I was worried about the poor who don't have a voice. That's what I dealt with for 10 years here in Orange County. I always advocated for them. And I felt that he had the ability to do something here because he has resources and lawyers. But hey, you know what? He got the win today. They'll have to reflect on how they're going to try to salvage this if you're the people. And they may not. I don't know if they're going to want to put the resources into a misdemeanor case. I don't know.
Right.
But then again, well, yeah, judges don't have absolute immunity. I didn't say that. I said any immunity for issues orders from the bench. So it's limited. That's right. They don't have immunity if they get into a car accident outside the courthouse while they're driving, but they have immunity for the orders that they make from the bench, at least in California. So you can say they don't have absolute immunity, but I never said they don't. I said they have immunity in the courtroom.
There we go. Clarifying that. Yeah, a lot of people are saying Chille will be a holy terror after this. Certainly will embolden him, I think.
Well, is this the first trial? Is this the first trial that he won where he didn't have a lawyer, where he wasn't his own attorney?
I don't think.
He's always represented himself.
Okay. Well, he did the right thing by getting a lawyer. I always told him that was the right call. You don't want to mess with this without an attorney. No way.
Yeah.
Is it really over, or is the DA going to say, you know what, we're going to have to file an appeal, and here are the grounds? But again, remember, it's limited to the record. So did the record of that I think it was a 12-minute video that they showed to the cops, did that 12-minute record show where Chille said no twice? to where he says, "I'll detain you," and then Chille, he says, "Step back," and he says, "No." Step back, and he says, "No." The video clip that I showed, I can't remember. Was that part of the record? If it's not part of the record, then they got a motion to augment the record, and maybe it's too late.
No, it was in the trial.
So I don't know what I don't know where they go from here, but dramatic win. It's like a Hail Mary pass, that Doug Flutie thing, Boston College, last play. Throw the ball and spike it.
Yeah. Wow. Anybody else have any questions for Pat? Well, we got him. I think he's probably he's a busy man, so he's going to have to probably bounce sooner than later. Double D says for $10, I need closed captioning. The castrated nut swingers super chat swingers chat is super amusing. I haven't seen this much collection of purposely ignorant in a long time. He still had 4 months in the dungeon efforts. Yeah.
Oh, one last thing before I forget.
Yeah.
Nowhere did the prosecutor bring up the fact that Chille was nodding his head on the record when the judge said that he wants this. He wants to be arrested.
Right.
That they quoted it in their brief on page 15. The people. That was spectacular that they put that in there, but they did not even mention it. They didn't even mention it. And I was surprised that Judge Levitt was actually going to rule from the bench today. A lot of times what they do is they sit and they think about it again, and they, kind of mull it over, maybe even ask a few other fellow judges for their feedback. I think she came in already with the idea that she was going to overturn this decision.
I agree.
Because she was nodding her head when Orem was speaking and was very attentive, and like you said, wasn't interrupting him, but she turned on the prosecutor and was interrupting him, and I just think that he didn't have anything in the tank. I mean, if there was any time to persuade, it's right now,
Yeah. I'm sure a lot of people are sort of disappointed by this. But hey, this isn't like, this guy keeps saying this over and over again. So there you go, buddy. You got your attention. You can stop saying it now. But I mean, I don't hate Chille. I just find all this really fascinating.
Can I respond to that?
Absolutely.
I don't know. First of all, I don't hate Chille. I don't know him. Okay. I'm just here to look at the constitutional questions. And if you were paying any attention, you would have noticed that I put up videos that I spent a lot of time on, which gave him information that would help him. So no, we're not haters. We're just trying to analyze the stuff as it hits us. And I'm going to tell you right now, did you just hear me say that I tip my hat and congratulate him? So would you knock it off and open up your ears and think for once?
There you go. And like I said, I've said it many times, I started this channel because I disagreed strongly with Chille's driving while live streaming. So I set out to put, which I dare you right now to try and defend that shit to me, Chille followers.
Chille's got his haters, but we're not those haters. Okay. Yeah. We were not his adversary, never have been.
Yeah.
So the fact that we're commenting on it doesn't make us a hater. It doesn't make us pro Chille. We're actually pretty neutral here. We're just trying to figure it out and look at it. And like I said, lightning struck today. That doesn't make us haters. It doesn't make us trolls.
Yeah.
Sounds like that's what you are.
Yeah. This is exactly. You're the one over here,
I'll tell you, may I be so bold as to say that if I was the one arguing this case for the prosecution, I would have saved this case. I don't think that Judge Levitt would have been able to. Maybe I'm not saying that I'm invincible. I'm not. I'm a human like anyone else. I can make mistakes, but I would have come in with way stronger arguments. I don't think it would have been so easy. I don't know that she. I didn't hear the ace cards being played at all today, and the briefs. They filed the one brief. I thought it was sufficient to hold the win. I was wrong, and I'll be the first to admit when I was wrong. But I thought it had enough, especially when he was nodding his head. That was the one I wanted. And they also mentioned the Wilson exception. So those were two important things. But they did not argue that at all today during oral argument. And now she's already made her ruling.
Yep. Melvy's asking if he thinks there's any chance he'll get charged federally for the content of his jail calls. I
No,
I doubt it.
no, not especially with an acquittal. No,
Yeah.
I don't think so.
Yeah.
I think
No.
he's got to get on their radar a lot more than this. Okay.
Yeah, exactly. Well, yeah, I know a lot of people are disappointed with the results, but I mean, it is what it is, you know. I mean,
Hey, you know what? Life's going to go on.
and
There is another trial coming up, right?
that's right. And that was my other question. Since they're the exact same charges? I mean, slightly different scenario.
Circumstances, yeah.
Yeah, circumstances, but
I didn't think they were the same charges. They were similar charges because it was in the city of Las Vegas. I might be wrong about that. I haven't looked at the case in a little while,
No,
but
that was the U-turn. That was city. They're both.
yeah, this is both obstruction and resisting.
Yeah, it was the sheriff's department.
It was at the scene of the fatal accident.
Car accident, yeah.
And you know, during the trial, the prosecutor, she brought up his pattern of getting into these altercations. Do you remember that?
Yeah. Yeah.
And did you hear the prosecutor today talk about this? That hey, pattern must count for something.
Yeah.
You know? It doesn't matter whether or not you know Chille. That's irrelevant. I don't know why that guy spent time talking about that. It matters for the fact that it shows state of mind. It shows planning, preparation, intent. Yes. Yeah.
That's what I say all the time. The intent.
Yep. So again, I mean, this affects my life not at all, really. And government. I never know how to pronounce your name. Go or G0FDT said Chille hasn't been driving like that for a while. I'd like to think that's because of the attention I put on him. He was well aware of my campaign to stop him, and good. And so as far as I'm concerned, the channel has been a success. Anything after this, we've just been following this guy because he's amusing. Let's not kid ourselves. And there are interesting legal questions that get raised by all this. Yeah. And now you've seen what what an ill-prepared prosecutor can do to a case. I mean, Orem just spun the narrative that Chille's been trying to lay out all this whole time. And he just steamrolled the guy to the point where he was taunting him at the end for it. Like, this guy, look at him. He looks like he's about to shit his pants.
Yeah, the kid was asleep at the wheel.
Yeah. So.
And you want to know something? Remember how Orem was when he first came in on the bail hearing, and he floundered very badly. He even gave the judge the wrong reasons for the conviction. And she says, "I didn't convict him for that. I convict him for his actions." And Orem, stood there and didn't say another word because he realized he had said the wrong reasons for the conviction. But that's because he just got done with a murder case, and now he's walking into this albatross. But he had time to prepare. He came in really prepared. Mm-hmm. The prosecutor had a little notebook. I didn't see paper. I didn't see notepads. I didn't see a bullet point of arguments to make. What I saw was almost expecting to get the win,
That was his bookie spiral.
I mean, listen, Orem was checking the boxes as he went down the list, and he led off with ineffective assistance of counsel, which I thought was a complete losing argument. But then again, if you're not going to counter these arguments, you're giving the side the win anyway.
Yeah. Wow, what a fascinating turn of events.
Yeah. Well,
I mean,
congratulations to Chille. He
absolutely.
He won. We got to respect the decision. It's the process, and he went through it and he won.
Yeah, we'll keep getting content no matter what.
He'll get a hero's welcome. He'll get a hero's welcome, and you know what?
Oh yeah,
Orem's saved his ass. Right?
Yes,
he sure did. Yeah, yeah.
And remember, one last thing: this will now not count in the second case. He was acquitted.
Well, what do you say? Oh, right. Yeah, they won't be.
You can't argue a pattern in practice. The guy was acquitted. You'd never bring it up now.
Yeah. Yep. This is definitely going to embolden him in many ways. So, yeah, I would expect his tone to be very gloating. And again, I guess he earned it. So, or his attorney earned it for him. That is.
Well, here's what's really, like we said before, what's really ironic. One of the things that courts are always worried about are inconsistent decisions. So you've got the federal judge in the federal civil rights case involving the same cop, okay, saying there was probable cause, which led to charges being, causes of action being dropped through the later amendments of the pleadings that Chille had to do. Which, of course, Michael Mee, the incompetent, and I'm using it with quotations, the so-called incompetent attorney, is arguing and opposing right now. So, I've never said that Michael Mee's incompetent. He's not. Okay, he's a skilled trial lawyer. I saw what he was trying to do with the hand he was dealt during Chille's trial, and right now you've got a federal judge saying there was probable cause for the arrest, and it looks like this judge, and I only caught the tail end because I was working on something else at the moment, but it looked like she was saying it was unconstitutional. Is that what she said? Yeah. She said it really quickly, and then I didn't have a chance to hear it because there's a delay on my side. But it sounded like it was unconstitutional or something. I think is kind of what she said under her breath a little, but whatever. You got one federal judge saying it was constitutional. I mean, there was probable cause for the arrest, but it looks like Levitt is saying there was none.
Wow. Well, I hope all you guys and gals out there from Team DLZ who are in here making your comments can appreciate that you're not getting blocked. You're not getting censored.
That's right. That's right.
But I'd like to remind you that your hero
we're all blocked over there.
Me. I can't exercise my First Amendment over on his channel. So just keep that in mind. And also, I should also remind you that he threatened to sue me and then promptly backed down when I pointed out over the course of a couple videos how stupid he was being. But no, enjoy your victory. It's good day for you.
Yeah.
Congratulations.
This is the system.
Yep.
I'm giving him the win.
Yep.
His attorney kicked ass, and hey, you know what? It is what it is.
It is what it is. So everybody, just go about your day and just remember better things. I don't know, puppy dogs and lollipops.
Just remember, success is a journey, not a destination.
Hey, let me close with one final funny comment before you guys sign off.
Sure.
Okay, so this was a few years back. I was over at the Central Justice Center on a criminal case, and I was at an arraignment with my client, and the guys before me were there for, I'm sorry, it wasn't an arraignment. I was there in court, and the guy in front of me, was up with the case, and I was waiting with my client, and we were waiting for the trial to end, and we were told it was coming to an end. So we were there for a meeting with the prosecutor, and the guy got convicted. Now, I don't know any of the facts of the case because it really didn't concern me, and I was just walking in the tail end of it. And the guy that got convicted looked at his attorney and he goes, "What are we going to do next?" And he says, "I don't know about you, but I'm going to go have lunch."
Oh, man. Brutal. Yeah, I'd also like to.
He must not have liked his client at all. He must have really hated his client.
Yeah, well, that's pretty brutal. I'd also like to remind all you Team DLZ folks out there that Pat, he has no truck in this.
No.
Right? He's interested in it from a constant. When Chille, although Chille has stopped calling himself a constitutional law scholar now and is starting to call himself a First Amendment auditor, perhaps again because of the attention we were all bringing to the concept of UPL and the dangers that might pose for him if he kept doing it. Patrick was laying out arguments that Chille could have used. I mean, not that it ultimately mattered, but he was not taking any sides in any of this.
Yeah, so, Chille supporters have actually notified me many times that they thought I was actually helping him. And I had other people saying to me, "Why are you helping this guy?" And I said, "Well, I'm really looking at it on both sides. What would help the prosecution? What would help the defense? Because arguments are going to be made on both sides, and I wanted to look at those arguments."
Yeah. Again, yeah, nobody's pro or anti Chille. I was anti-Chille's behavior vis-a-vis road safety. Pat, as you said, as I was saying, Chille calls himself, or up until recently called himself a constitutional law scholar. Pat is a constitutional law scholar.
No, I do not call myself that.
What
There
I'm
are,
saying.
I know, but there are some true constitutional law scholars out there that are really dazzling with their knowledge of the history of the Constitution. Chemerinsky, people like that. My professor in law school, she was certainly a con law scholar. She clerked for 3 Supreme Court justices, and her whole career was dedicated to the Constitution and the line of cases. And I couldn't hold a candle to any of them.
Well,
my area of expertise is in defamation, which is constitutional questions of the First Amendment, and I love Second Amendment cases, but I don't really handle that too much because there's gun lobbies that have lawyers that are all armed up for that anyway. So no pun intended. But I do love the First Amendment, and this was a First Amendment case. So
right. Well, it would certainly be fair to say that you are light years ahead of Chille in knowledge of that nature. Although, Orem seems to. I mean, what did you think of how he put the First Amendment argument in there today? It would seem to be pretty effective.
I really thought it had no merit at all.
Right.
I mean, this was smoke and mirrors all the way. Well, there are reasonable time, place, and manner restrictions. This isn't really a time, place, or manner restriction case. This is more about the fact that he refused to cooperate. But he so brilliantly framed it that way that he got the prosecutor within that maze. And that prosecutor kept bouncing off the walls on that. And the more you do that, the more legitimacy you give to the opposing side. You got to stake your claim. You got to say, wait a minute, no. Yeah, that's all the constitutional stuff. But the fact is that the officer told him to back up twice, and he flatly refused when he said no. It wasn't a matter at this point whether or not, what Chille said was protected speech or not. Wilson says that protected speech is going to happen regardless in any arrest. What matters is the behavior. Just like the judge sentenced him. She said she sentenced him based on his behavior in the street, even though I think she actually added more time because she was mad at him about the way he acted in court. We can't prove that because she warned him about contempt, and that was another thing the prosecutor dropped the ball on.
Yeah.
About the biasness. Well, first of all, she warned him she could hold him in contempt and put him in jail, and she said that's not my intent today. And I checked off all the different things that he said that would be contempt if I did them, and she got she gave him a free pass. Then she gave him mid-range sentences. And the argument that he had that was a really great argument, I don't know if it's true or not, was he said he found 6 cases where she, for similar charges, never sentenced someone to jail at all. Now that, to me, if that was true, that would have been a great thing to add to the appeal, augment the record to include it, because that to me would tend to suggest judicial bias. Because what made him so special that he merited, 6 months in jail? Which I thought was a harsh sentence. I did.
You said that from the onset.
I said that from the onset that the charge of obstruction was the questionable one. But then Wilson came out in February 2024, and Wilson provided the carve out that the prosecutor didn't mention. The judge, did she not like Chille? Yeah, I don't think she liked him at all. Okay. Was that under the Echeverria decision in the Ninth Circuit so obvious to me or to anyone else that it would merit, recusing her from the bench? No, because the judge has the right, just like Judge Leavitt, to control what goes on in her courtroom for safety, security, protocol, whatever. And I saw that as a very bland, hey, everyone's got to give up their phones. And that would necessarily, and when Orem said, well, that's how the trial started, already off on that foot. Well, of course it did, because the first thing a judge is going to say is, hand over your phones. I don't want you guys recording. I want to be sure that no one's recording. But he made it sound like she already had it in for him before the trial started. Prosecutor never said anything to counter that. I could go on and on about this. Okay.
Yeah.
Like me, or myself, not me, Michael, me, but myself, or maybe even the trial lawyer that handled the case, we know the facts so well that we would have countered all of this, and I think just obliterated it. I did not see this win today. I'll admit it, but then I didn't see a prosecutor putting up much of a fight either.
Yeah, I was going to say your prediction was sort of based on the prosecutor having a grasp on what the case was.
You know when they're not, you know when they don't know the facts, when they start going into generalities and they start repeating themselves, you know?
Yeah,
and
Orem had that guy chasing his tail. It was, you know, yep. And again, the judge was nodding along early on from Orem. So well, that's the way the cookie crumbles, kids.
Remember what Charles Barkley said when some guys were about to shoot free throws, and the announcer said, "Oh, this guy's got a 90% free throw shooting percentage," and Charles Barkley said, "Throw that statistic out the window." He says now he's got to shoot them with the whole world watching.
Yeah.
And never underestimate pressure. Like Al Pacino said in The Devil's Advocate, pressure changes everything. And it could very well be that this young attorney was feeling an immense amount of pressure with the TV cameras there, with all the publicity of this case. And you know what? It's affecting his thinking. It's clouding his judgment, and he starts repeating himself. You'll see that on the presidential debate. You know, they start repeating themselves, right? Because they're human. They're under the stress of the moment, and their brains are kind of in a fight or flight mode.
And when they bury their hands in their pockets, that's kind of a thing of fear too.
Yeah, that's what the prosecutor did right away. Remember his hands in his pockets?
Yep. I noticed it right away, and I was always told to attack when they put their hands in their pockets.
I mean, he was projecting insecurity. Okay, and when he went for the drink of water twice, judges noticed that stuff. And anxiety and nervousness is fine. We all have it. I have it. If I had to argue in front of the Court of Appeal, I've done it, I think 4 times. I would be nervous. Absolutely. It doesn't matter because we care.
I'm just watching this soap opera at this point. So
I know.
What
it
a
is
weird day. Yeah,
it's
what a weird day. And I'm sure Chille will be really fun to watch after this. I mean, he's gonna be a good job, Chille.
Hey, he won.
Oh yeah, right. BSVT. You'll hold water with Darcy. Sure. Come on, we'll set this up for tomorrow night.
Yeah.
I don't have enough time in the day to battle people who want to just put negative stuff out there. You guys can say what you want to say. The reality is that I'm congratulating him. Underscore that.
Yeah.
I congratulated him. Okay.
They're confused.
Yeah. BSBT is just likes attention.
Confused.
He just likes attention. That's all. Blind Mike, $5 shout out from Who Are These Socials? Enjoy the Chille coverage. Oh, thanks, man. Yeah, I saw you guys covered briefly when he was planning to sue me, which he bitched out of, by the way.
Yeah.
So, remind all the team DLZ about
and
that.
the 1 year statute of limitations. Yeah, the 1 year statute of limitations under 425.16 is already passed anyway, so that's time barred. You would throw it out on a statute of limitations defense.
Too bad, but yeah, who are these socials? Is pretty fun stuff. If you guys, I don't know if Linda's in here. If you pop them up. But.
I mean, in terms of you guys thinking that we're haters, look at my face. Do I look like I'm upset that won or lost? Do I really look like it's affecting my life? Okay.
Yeah.
What more do you want from us? All right. I'm not, I'm not going to be out on the street corner screaming and upset, and it's going to ruin my day. I'm going to have lunch. I got some stuff, a lot of work ahead of me this week. And you know what? I just wanted hey, he's entertainment. Okay.
Yeah, that's exactly right.
I mean, he is.
That's
it's
exactly
a chance for us to get together with all you guys and have a good time. I mean, I wouldn't make these in a vacuum. I wouldn't do this coverage in a vacuum, make my videos in a vacuum. It's all you guys that make this any kind of worthwhile for me, because believe me, and I think Pat is probably in the same boat. I'm monetized, but it doesn't come anywhere near like the amount of effort I put in. And I'm sure Pat's pay rate is way above mine, so I don't want to.
Okay, I never hide anything on my channel. Yesterday I took a look. 1.3 million views, which is staggering for me. I couldn't believe it, but that's what it says. my channel's made $1,725, and I put the word "made" in quotation marks. You know why? Because I've given more money away to charities, police dogs, and everything else than this channel will ever make. This channel is not going to be a source of income for me. It's a source of lost revenue, because every hour that I spend on a video is an hour I'm not billing. Okay, I do this because I like it. All right, I like doing this. As long as the cases are interesting, I'll continue to cover them. If they're not, then I don't really have any stake in it. There are other cases out there, and you see, I don't even cover them because I don't really see a constitutional question about it. So
Yeah,
I donate to the things I like. There was that police dog out in Wyandotte Police Department, Officer Ice. Remember, he was accused of stealing a sandwich. I came to try to defend him, and he took the Fifth Amendment. Do you remember that case? The dog did exactly right. He did not confess. He did not talk to the police. And they put a Facebook post out there. And so they said he was stealing a sandwich, and which is conduct unbecoming of an officer. So what did I do? I wanted to defend him. Other lawyers did as well. And I contributed money to the police department, specifically to that lieutenant, so they can make sure he and Officer Jacks get all the dog treats they could want for quite a long time.
Yeah.
But that was an interesting question. A dog being accused of a crime.
Tracy, the reason the judge didn't take the state's phone because they're officers of the court. That's why they didn't take me's phone either. When you're an officer of the court, is different than being a defendant or a bystander. They keep saying this over and over and over, and I just want them to understand that the prosecutor is an officer of the court, and they're expected by the judge to uphold the rules of the court. So that's why that they didn't.
That's right. But you know what? Even we can go too far. If, for example, a horrible song is playing during the middle of the trial because you didn't put your phone on silent,
or a bad ringtone.
Oh my gosh, there was
I've heard it.
Yeah, at Moss Courthouse in downtown LA, we were all sitting there. There's a side area in the department. We're all waiting. All the lawyers are just stacking up. And this lawyer, I don't know what happened, but the song that came out was one of those songs you would laugh at if you heard it, right? And it started playing loud on his phone, like he listens to that kind of music.
Like I got a brand new pair of roller skates or something.
Yeah, something like that, or maybe Tiny Tim's Tiptoe Through the Tulips. And he didn't know how to shut his phone off. And as it continued to play, we were all laughing. The judge heard it and interrupted the court, and even she thought that was funny. And, the implication, of course, was, do you really listen to that kind of music?
Oh, dear.
But yeah, we'll get in trouble if we do that. But typically, no, we keep our phones. We just have them on silent.
That's right.
Marshall Payzant for $2. Good job, gentlemen. Well, thank you. Thank you all for being here. I think we're probably going to wrap it up here. And like I said, get on with our days. Don't, I should hope this, you don't let this affect your life in any kind of major way. It is what it is.
Down goes Frazier. Down goes Frazier.
Right, exactly.
Doug Flutie throwing that pass when time was out.
Guys, Chille's live. Chille's live via chopper cam evading VMPD right now. Yeah.
Hey,
that would be something.
Wasn't that USC, the USC band, too? That was a good one.
Oh, yeah.
Yeah.
Stanford one, right? Was that the Stanford Cal game?
Stanford Cal. Yeah. Or no, USC Stanford. Yeah.
Right.
Where they lateral it back. Yeah, absolutely. Yep. The band had already went out on the field to celebrate.
That's what we got here. We've got a no time winning, or like an extra time in the World Cup when they scored the goal with almost no time left in extra time.
Wow.
That's what we got here. All right, gentlemen, I got to roll.
Yep.
Thank you, Patrick.
Thank you, Pat. Thank you very much for everything. This was nothing if not interesting and instructional.
Yeah.
I had fun.
A lot of fun.
It was fun too.
Okay, guys, I'll see you later.
Thanks, all right.
Bye.
So, I will miss the phone calls. I'm not gonna lie.
Yeah.
So they kind of nauseated me and amused me at the same time. And but we got enough for several albums worth of material there.
It's entertainment for us, and that's why I
Exactly.
say. And Chille has never ever failed not to give us content to have fun with. Never.
Yeah. Well, the driving ones for me were not fun.
Well, no. That's it. I'm not talking about that.
But
I'm
yeah,
talking
since
about
then, yeah, I mean, him threatening to sue
just
me.
like
Was,
my video libraries. I try to expose the DUI thing because to me, just like distracted driving, they're both one's as heinous as the other, and it's deadly. I mean, it's a bad thing. So, but yeah, beyond that, I'm talking about the entertainment value.
Yeah, no, I get you.
Filing motions improperly and things.
And
like
I
that.
will admit it, I did a little happy dance when he he threatened to sue me on his channel. I was just like, yeah. And then right after that, he blocked me, and I wasn't able to comment.
Right.
Just
we have not blocked one person today. There was 900.
No,
There's almost 1,000
I
people
banned that
in
one
here.
guy.
Well, that was,
he
that was
spamming,
troll. He was spamming. Yeah, that was early on.
Addresses or something. I don't know what he was
Right.
doing. Yeah, you have actual freedom of speech over here, unlike over there. But yeah, if you're not a fan of Chille, boy, you're really not gonna like what the next what's coming, because he's gonna be twice as insufferable. If you find him insufferable now, he's gonna be even worse. But again, just remember, he's just a goofball.
Yeah.
As long as he's not endangering people.
That's right.
That's
right. Superhuman never endangered anybody.
That's right. We need superhuman.
That's right. He worked on their diet.
And I'll give Chille another compliment. He did not. I predicted he would look like complete dog shit today.
Right. He looked a lot better.
He actually looked better than he did in his original thing. So I was wrong about that. Boy.
Yeah, he needs to get some Grecian formula.
He's an older gentleman now. But yeah. Well,
No, he did look a lot better, and I thought he was going to look pretty rough. The way he was talking, I mean, when he's talking on those calls, like he was dwindling down to nothing.
Walking on air right now. Oh my God.
Right.
Freedom. Whatever. But the hope. Really, what should have happened is he should have gotten some sort of anger management or counseling or something. And let's not forget, he could have avoided all this if he'd just taken the plea up front. But whatever. What a journey, gang.
Yeah.
Never-ending twists and turns in the Chille saga.
I like the way watching the comments and stuff throughout the day, and I say this all the time on the channel, how cell phones have become an extension of your body. People are so offended that the cell phone is not in their hand. You take it out of their hand. I was watching a video yesterday where, absolutely was not going to give her cell phone up for nothing. They were handcuffed her. She had a grip on it. She wasn't going to give it up. It's just a cell phone. It's just a phone. I mean, they weren't filming or anything. It's just a phone.
Yeah. Yeah, and everybody give a round of applause to Linda H, because she might not notice her in there, but she keeps the whole thing together and on track. So we really appreciate you, Linda, what you do. Yeah. Again, we're not like pro or anti-cop or whatever here. It's case by case.
That's right.
The only you guys.
I have both of them.
You guys got to come up with new material. This shit sucks.
I have bad cop videos in my channel, and I've got the other side. I've got it all. It's about right and wrong.
Yep, exactly. So there it is, kids. All right,
and that's subjective. That's why we have courts.
Precisely, and we, sometimes it goes
that's right.
In unexpected directions.
That's right.
That's what it is.
Absolutely right.
All right.
System played out.
Yep. You guys take care of yourselves. What day is today? Wednesday?
Thank you, Yvonne. Thank you for your help. Thank you, Linda. Love
Yeah.
you. Love
Thank you,
both of
everybody. Thanks for all the. I didn't miss any super chats, I don't think. But yeah. That's all the news there is today, kids. I'll try and go live tomorrow. I'm still dealing with a lot of stuff, so we'll see how that goes. But
yeah, get by and look at. Make sure you go by and look at Dick Bag's merch. He's got some cool merch. Get yourself a coffee mug. Yeah,
thanks for the blatant shill, Ram.
Yeah, get you one of those coffee mugs. They're good coffee mugs.
Yep, or yeah. I don't have anything to add to that. I'll keep you posted on tomorrow, and that's that. Yeah, I don't know when Chille exactly is going to be out. Maybe they'll process him out today. Who knows?
They always take that extra day. I guarantee you it'll be 24 hours.
I got you.
They get and probably 30 because they get the bill. They get the bill. Believe it or not, that is an issue. They get the bill of the state.
Gotcha.
For an extra day once it hits a certain time. So.
I gotcha. Well, yeah, I'm sure there will be something Chille related to. I'm sure he'll do something tomorrow, so maybe we'll go live and discuss that. I don't know. We'll see. All right, I gotta get out. All right.
Later, Gators.
Yeah, later, Gators. Yay, Team DLZ. Congratulations. Yep. Big win today.
We'll be all back next week.
Yep. So long, suckers.
Later, Gators.